Thank you.
Maybe this is your lordships. My lord, I beg to mention
Yes.
item number 8 in orders. Here, my lord, we have challenged the detention order, and the state government has revoked the detention order. So I pray that this writ petition may be allowed to withdraw, my lord.
Withdrawn. You want to withdraw?
Yes, item number.
Okay. Mr.
B. Soto, my lord.
B. Soto, line counsel for the petitioner, has an instruction to withdraw this writ petition criminal and prays for allowing him to withdraw the same. So the prayer is allowed. This writ petition criminal is dismissed on being withdrawn.
Congratulations.
Okay. Okay, Mr. Jed. Okay, Woli, line counsel for the respondent number 4, and Mr. Angami, line counsel for the state respondent number 1, 2, and 3. 1 and 2 are also present. Okay.
Your lordships, I also beg to mention item number 13.
Lordship, in this matter, I have an objection. If they are going to seek for adjournment, then the interim order has to be vacated, Your Lordship. The interim order dated 30/8/2022 has to be vacated. They have been repeatedly seeking for adjournment, Your Lordship.
This is for hearing.
Yes.
Hearing.
Wait for some time then.
My lord, my senior is out of station, so we have no option, my lord.
He can do it.
Wait, let us see. Just let us see. There is an interim order also. Let us see what we can do. Okay.
My lord.
Lordships.
Yes.
Lordship, I beg to mention item number 19 and 20. Lordship, this is a hearing item, Lordship. But there's some subsequent development with regard to the appointment of the petition, the applicant's Lordship. Now there are some subsequent developments. So, Lordship, if I may be given 3 weeks' time, I want to place it on record by way of an affidavit, Lordships. I've taken the concern of the.
Okay. So, Mr. Mose and Mose, line counsel for the appellant. Some is that there has been a subsequent development during the pendency of this writ appeal, and to which he would like to bring on record by filing affidavit.
Yes, Lordship.
Okay.
Place of the course.
They were praised for some time, for which he requires some 3 weeks' time.
3 weeks, sir.
Okay. And praise accordingly. The prayer is allowed. List his matter after 3 weeks.
Deeply obliged, Lordship.
weeks.
May I please, Lordship? My lord, I beg to mention item number 17. I'm mentioning on behalf of Visa Momi. My lord, I'm informed that he has taken consent from the opposite party, so let the matter be listed after 1 week. My lord.
You've taken consent from the petitioner. Okay. Petitioner is also present. Okay, no objection.
Yes, my lordship, let it be taken up next week. Yes, next week, Lordship.
Next week. Yep. Mr. Tosio Longkumalani, counsel for the appellant is present. Mr. Tibapam. You
Hearing
are
on behalf of Visa Momi.
appearing on behalf of Mr. VG Mobilana PP, raised for adjournment to adjournment of the matter for a week,
Yes,
to which the land council for the petitioner has no objection. We are allowed. List this matter next week. After a week, huh? Okay.
much obliged.
Yeah, this is my lord and my lady. I beg to mention item number 7 on behalf of my colleague, Ms. Mary. She's yet to receive instructions, so if this mechanic be listed next week.
Item
7,
7.
yes.
This is for what otherwise?
Uh,
My lord, the IA is for continuation of delay
yes,
and the petition is a criminal appeal from chair lordship.
You have an objection?
no, the thing is, service upon respondent number, private respondent.
Wait, let us see.
Oh.
Okay. Yes.
May it please your lordships, I beg to mention here in item number 14, 15, and 16. May I pray that this matter be listed on 30th of July, lordships.
14, 15, and
16.
why?
Lordship, my senior ASO is out of station, so we should be today.
So the respondent is government.
Yes, ma'am.
So. So. Mr.
The blue marker, lordship.
Narayan Council submits that his senior, Mr. A. Joe, is out of station. Therefore, pray for adjournment of the matter for matter. When do you want, you said?
30th of July.
And to be listed on 30th of July, to which Narayan Council for the respondents have no objection. The prayer is allowed. Please pray for the farmer. List his matter on 37. Okay.
Thanks so much.
Is it?
Yeah, we done something.
Is it? Then,
Maybe this is the lordship. Yes, yeah, lordship, I beg to mention item number 6. We have filed our additional affidavit this morning, no?
item 6.
Yes, lordship. The matter may be fixed after 2 weeks.
Writ petition from you. You're for the petitioner.
Petition.
Whether the state or the respondent has filed any affidavit.
Yes, the petition I've already filed, your lordship.
Okay, and
No, I have to file.
you are yet to file affidavit.
No.
Already filed.
Yeah.
She filed it, no.
You have filed,
Additional affidavit, your lordship.
you want to file additional
I
affidavit
filed this morning.
this morning?
Yes, lordship.
Okay.
So the matter may be listed after 2 weeks.
Have you received the copy?
Yes,
Additional affidavit?
Yeah.
You have also received the copy. Okay. The Miss
YS form.
YS form, Narayan Council for the petitioner submits that she has filed additional affidavit this morning itself. The Narayan Council for the respondent, Mr. Jedengule. Narayan Council for the respondent number 4 and Miss Noli, correspondent 1, 2, and 3. Submitted, they have also received the copy of the additional affidavit filed by the petitioner. As prayed for by the learned counsel for the parties, list its matter
2 weeks.
after 2 weeks. Okay.
For motion, item number 1.
And Mr. Lordships. Lordships, the detention order for the next petition was expired on 2016-2025 and was further extended. Therefore, allowed me to withdraw the writ petition with liberty to file fresh.
It was further extended. You have not incorporated. Okay, Miss
Madogichi.
Learned counsel for the petitioner submitted the detention of the petitioner has been further after filing of this. Okay, after filing of this writ petition, the detention of the detainee has been further extended. When? Do you know the date? Further extended. Therefore, now she wants to withdraw this writ petition with the liberty to file afresh by incorporating the further extension order. Okay. The prayer is allowed. This writ petition is dismissed on being withdrawn with liberty as prayed for. Okay.
For motion, item number 2.
Yes.
None, under with NDPS Act, Your Lordship, so at this stage, notice may be issued, Your Lordship.
Yes, no, please. Yes,
All right, I'll not accept notice of behalf of respondent 1 and 2.
1 and 2. And Jaren. Please. And then Yangarvati 4? 4. Okay.
Also 3. Deputy Secretary,
Chairman.
Advisory Board.
Who is for 3?
So that's, but magistrate, autonomous body. It's an autonomous body.
Is it?
So they
Who generally used to represent this 3? No. Who used to represent in this court? In other writ petition?
Yeah, not that.
No standing counsel.
Yes, they got
Okay. Okay, hard miss. Learned counsel for the petitioner. So by filing this writ petition, the petitioner challenged petitioner 6 direction, 6 to quas. Where is the prayer? The detention order number CON/with NDPS/10/2025/126 dated 9/5/2025 issued by the Special Secretary Home and further prays for and prays for release of the accused. The immediate release of the accused. And also to direct to pay compensation to the detainee for illegal detention. Staff. Issue notice. Returnable by issue notice, okay. Since Ms. Inauli accepts notice on behalf of the state respondent number 1 and 2 and Mr. Yangarwati for respondent number 4, no formal notice need be issued to the said respondents. Stop. The petitioner shall take steps upon the respondent number 3 by a registered post with AD within 3 days from today. Okay, stop. List this matter. After 4 weeks. After 4 weeks. Okay. Okay. Then after that, the petitioner shall furnish requisite extra copies to the learned counsel appearing on behalf of the respondents. Okay, during the course of the days. Okay.
For admission, item number 3.
Yeah, this logic.
Yes.
My lady, this matter relates to Sumutu PIL taken up in this honorable court with regard to the 4-lane ongoing construction of the Kohima National Highway. We are taking up this matter since 2019. Lordship, the last order.
Nodding officer to remain. Nodding officer shall remain present.
Lordship, may kindly refer to the last order passed on 25/6.
Yes.
2025.
Yes.
My lord, some affidavit was received by me this morning, last night also. But then, kindly allow me to read the order so that we see the compliance, whether the directions has been complied or not by the respondents.
Okay, please.
Lordship, directly I go to A, acquisition of land in change 126.
Yes.
May I, Lordship?
Yes, please.
So the land to acquire the change 126 in the Bagla Bahar area is reportedly under the using department. Due to the onset of monsoon, the river has caused significant damage to the river bank, narrowing the channel and risking further damage, which would make the management difficult. Therefore, urgent acquisition of the land opposite of the river is necessary. The process for acquisition should be expedited and work should be continued in the meantime. The additional AG previously stated that the state of Nagaland acquires land following the provisions of Nagaland Acquisition and Acquisition Act 1965. It further submits a proposal for acquisition acquiring land in Bangla Bahar was made by the Deputy Commissioner Chubitima on 6/3/25 and submitted to the Commissioner Nagaland with the assessment. The outcome is still awaited. He requests some more time to obtain instruction regarding the current status of the process. Amicus Curiae emphasized that he has been raising this issue in the matter is pending since March 25 and require urgent attention due to the monsoon. He criticized the delay by the authorities, noting that the damaged portion of the road exposed at the beginning of the rainy season. He submits that there is a risk of which washing away the repaired portion, also immediate action is not taken to widen the river. Mr. George, the authority engineer, reports that on 16 June 25, a sudden rise in water level affected the top of the structure under construction. The expert committee is currently inspecting the site. He also informs that the estimates have been prepared and are ready for tendering. Amicus Curiae further submits that if the land belongs to the tourism department and not the private owners, there should be no difficulty in the acquisition. It urges that the process be expedited and work in this area be allowed to proceed simultaneously. In view of the above position, we reiterate the earlier order on 2/4/2025. directing the state of Nagaland, particularly to Commissioner Nagaland, to expedite the process based on the proposals submitted by Deputy Commissioner to Kohima. The state shall file a detailed affidavit regarding the progress and the government's proposal to acquire the land within 2 weeks from today. So far, I have not received the affidavit filed by the government. So let the
Yes.
additional AG clarify the position.
Maybe Your Lordship.
Yes.
Your Lordship, I have already communicated to the Commissioner Nagaland because everything assessment was done, everything was done, and ultimately the Deputy Commissioner Chubakima has submitted that proposal to the Commissioner Nagaland. And Commissioner Nagaland has to take steps to the ministry. So I have communicated all those direction of the Honorable Court on 4th July, but I am yet to receive any instruction from the commissioner. So, Your Worship, I may be allowed to take the personal step so as to enable me to file the affidavit on the next date.
Lordship, we have been raising this issue since January.
No, so in the last occasion also, it was clearly stressed,
Yes,
especially stressing these points.
my lady, that portion is in that drop fall area, just after Imapur, the steep portion. Now, because of in a place where the channel, the river channel is very narrow, unless and until we acquire land on the other side and cut the hill, the HNH 126 where certain construction has been done will be washed away because there was a heavy sinking area. There is a sinking area there. Since last year, since the beginning of January, we have been requesting the state government and to ensure that the land is acquired so that the river bed is widened. But so far, they are slipping of it. And in fact, Lordship may kindly see, we reiterate the earlier order on 2/4/2025.
Yes.
Since then, we've been, this honorable court has been directing and requesting the commissioner or the state government to let us know what is the progress. But till now, forgetting about the action, they are not even filing the affidavit. So my respectful submission, my lord, either the commissioner should be directed to be present in person to explain position. If you're not interested to file an affidavit, then the option is for personal appearance and explain the position to this honorable court, or the other option is lordship. And show cause notice has to be issued to the commissioner for not filing for disobeying the court's order and not filing the affidavit in time.
Lane is also stated to be belong to tourism department.
Yes. Now, my lord, the authority engineer is also present. He will be in a position to further highlight
Yes.
the actual position.
Authority, yes,
Yes.
regarding expert committee who were
He
at
will
that
be in a
time was
position to let us know.
inspecting the site. And then it was prepared estimate.
Since the
So what is the progress and the status? Yes, please.
The expert committee had visited, they had given a immediate solution suggestion as well as permanent solution suggestions. So we are going ahead as per that. And regarding the land acquisition, actually state government had issued the NOC and the compensation is also paid to the DC.
The
But when they are not
compensation
filing the
paid for
affidavit-
which one? Paid for which one?
For the one hill cutting in the chain, 126.
Opposite side,
Opposite side, yes.
already paid.
Yes, sir.
But why they are not filing affidavit? That is the issue.
Then if it is already paid, then why you are not filing affidavit?
That is the issue.
Already paid. Compensation paid to whom?
Wait, DC, sir.
Deputy Commissioner.
Yes,
So that Deputy Commissioner.
Whereas the land belongs to tourism department
yes, yes.
and it has to be paid to the tourism department only. The
Okay.
deputy commissioner only, but then, okay, then what is the problem?
Lordship, I need to take the further,
No, my lord,
so Lordship, with such further direction, I may be allowed to take this. And I personally take.
No.
steps.
Lordship, I don't appreciate the casual approach of the
Right, right.
respondent authorities on such serious matters. Maybe the commissioner is not aware of what is happening.
I have one more submission on this. There were two components in the payments made. One is for the land, one is for the shifting of the utilities, just paid to the PhD department. Now, the PhD is not ready to shift the utilities pipeline. They are asking us to remove it again. For which
What
already-
compensation, one is for land compensation.
Land compensation.
Land compensation, and other is
Second
for,
was for the shifting of the pipelines. There were two pipelines existing through that hill. For that, the payment was made to the PhD department. But even after receiving the payment, they are not removing the pipelines, which is again another obstruction for us to do the hill cutting.
Just a minute.
Lordship, in this matter,
See, this order has been, order was passed as early as on the April only.
Yes.
And thereafter, in the last occasion also, specifically stressing that the government is taking casual in this regard. It was submitted.
so Lordship, I have a humble submission for Lordship that with such direction, further direction, I will be allowed to take further step and I'll take the personal steps with the commissioner as well as the deputy commissioner.
Now, if you say that the commissioner is not cooperating or not giving any, despite of your seeking instruction, not giving any instruction, despite of receiving all this information from the engineers, or despite of knowing that the compensation has already paid and not giving any instruction to you, what you want the commissioner to be directed to be present in the court.
Lordship, since I represent the state, I will be allowed to get that last chance. I personally take steps and this matter will be listed on next date and I'll apprise the court by taking the necessary instruction from the authority concerned. So a chance may be given. And I'll take a personal steps to Commissioner Nagaland as well as Deputy Commissioner Chumo.
By the way, whether the work is in progress in the said location, engineer. So simultaneously, it was directed to be continued with.
Sir, after getting the clearance, we have initiated the tender process
Okay.
for the hill cutting.
Hmm.
At the same time, we have this problem with the pipeline shifting.
Pipeline
The
shifting.
department should do the shifting of the pipeline
Okay.
because we have already paid for that.
So department already have received.
Yes.
Who is representing the department? PHE.
Lordship,
PHE also represented.
PH is not a respondent before this honorable court, but we can direct the chief secretary.
Your Lordship, the thing is like this, that it involved tourism department, PHE.
No, Lordship.
Two
No,
departments
Lordship.
are involved.
No, Lordship.
No.
It is only with the pipes.
Yeah,
Removal of the pipes only.
let me
Pipelines.
allow to submit. So those two department assessment was done by the TC. So they don't need to implement because it is a lockout of the TC. So they have taken an assessment, everything was done for those, even the PHE regarding this pipe and all, and they have submitted to the Commissioner Nagaland.
Now, since the compensation has already been paid,
Yes.
I think there is no hinder.
They have to remove the pipelines.
Only the pipeline is to be removed. Otherwise, with regard to the lane, you have no problem.
Lordship, in this issue, my respectful submission is since it is involves various departments, let the chief secretary be directed to ensure that the pipelines are removed. Yes, removed because since several departments are involved, chief secretary will be the right authority. The respondent number 3.
Okay, rest will.
However, Lord,
Hmm.
with regard to the non-filing of the affidavit, this honorable court, I respectfully reiterate that should take it with all seriousness. Non-filing of the affidavit by the commissioner.
So last chance we can give, last chance.
While
Because now the lane has already been.
Sufficient,
That is
some
true.
observation has to be given,
That is true.
because they are taking us for granted.
So. What we'll do is that we'll direct the chief secretary to take care of for removal of the pipe.
Lordship.
And also the respondent shall file affidavit. The state shall file detailed affidavit regarding the progress.
Lordship.
covering entire. Now the payment has also been done.
Yes, Lordship.
And with, of course, regarding the removal also, then within a week. Okay, but matter will be listed after 2 weeks, but then you have to file within a week. Okay,
Lordship,
and
Then-
just a minute,
then may I go to the item B, Lordship?
just a minute. So this, just take the submission. Hmm. And A, acquisition of land and chain is 126. That is headline, underline it. This submission, Mr. George, he will be the recorded letter. Mr. George, the authority engineer, reports that the expert committee has already submitted a report, and the estimate have already been prepared and it's ready for tender. Tendering not yet started. Then the tendering and the plotting of tender is under process. He also informed this court that the land compensation has already paid and deposited in the account of the Deputy Commissioner Chumogidima for the acquisition of land on the opposite side of the river. Sorry, they pay the two compensation, that is one, the land compensation paid to the Deputy Commissioner Chumogidima for the land, for acquisition of land, and compensation also paid to the PHE department for shifting of the pipeline. Oh, DC only, okay, okay. The for acquisition of land and for shifting of the pipeline of the PHED staff. In this regard, we direct that the chief secretary, to for chief secretary to direct what? Direct for what?
Lordship, let the chief secretary file an affidavit. Actually, earlier on this, with regard to the cutting of the hill issue, the commissioner was directed to file an affidavit. But since the issue now involves removal of
The pipeline also.
and also other issues, let the chief secretary file an affidavit on that issue. But at the same time, the earlier direction to the commissioner also should be reiterated.
Okay.
Because he cannot run away from the responsibility.
Okay. In this regard, we direct the chief secretary to file affidavit.
With regard to the shifting of the removal pipelines.
With regards to the steps taken by the state with regards to the removal of the pipelines. Stop. We also reiterate that the state to file detailed affidavit regarding the progress and government's proposal to details as directed on 25/2/4/25 and 25/6/2025 within a week from today, within a week Okay, from today, start.
Lordship, may I report a submission of the authority engineer
Hmm.
that tender has been floated already?
Yes, it's
for-
under process. That is recorded.
Lordship, fine.
Tender is under process.
Lordship,
Floating of tender is under process. That is recorded.
Lordship.
Yes. Yes,
Then
next,
may I
next.
continue
Yes,
with sinking area at GNH 164?
yes,
The authority engineer states that work in the sinking area is ongoing. Although half of the culvert has been completed, progress has been hindered due to unresolved land compensation issue with the landowner. The amicus query emphasized that the district administration and the NHIDCL were previously instructed to negotiate and resolve on this matter and file report in that regard by 15/4/2024. However, no such affidavit has been submitted as yet. The learned additional AG requests additional time to comply with the earlier direction. After considering the submission, we reiterate that the district administration must negotiate with the landowner and find a resolution, then file a detailed progress report within 2 weeks. Mr. T.P. Jamir, Council for Respondent number 19 reports that slope protection work at GNH 164 has commenced following the award of the contract and prays for granting time to file a status report. The prayer is granted to file affidavit within 2 weeks. So, Lordship, the direction is twofold here.
yes.
At Roman 2, file a report for non-filing an affidavit with regard to the land dispute, and the additional AG was directed to file a progress report within 2 weeks.
Within 2
And
weeks.
responded number 19 to file an affidavit.
19 probably is filed.
Yes. So before we come to 19.
Yes,
I responded number 19, let the NHIDCL and the state government make a submission on this point. Because
We
so
launched
in
a-
this regard also not yet filed.
Regarding this dispute, regarding the diversion of the road for construction the culvert, all the assessment has been done, negotiated with the landowner, and on 9 July, this month, we have submitted to the executive director, NHIDCL for the acquired compensation.
So there was a negotiation between the.
Yes, it's already done.
Okay,
Now, the thing is, we received a copy only this morning, so I may be allowed to file affidavit on the next step,
okay.
explaining all the details. Otherwise, there is no land dispute, there's no problem from the hindrance from the landowners.
Now, no, yes, authority engineer. So could you just highlight whether there is still there is any hindrance? Oh, yes, you're the contractor, yes.
Yes, Lordship.
Hmm.
The issue is already resolved, Lordship. We have released an amount of rupees 48 lakhs for land compensation. 48 lakhs
Okay.
for land compensation. Lordship.
Hmm.
They have submitted, Lordship, they state, and which has been received by the NHIDCL, which is already forwarded to the headquarter, Lordship, for approval, Lordship.
Okay,
then Lordship, let the NHIDCL and the deputy commissioner file affidavits on this issue. And at the same time, whether we can go ahead, whether the people on the ground can go ahead with the work. Because if landowner issue is resolved with the landowner in good faith, whether the people on the ground, the correspondents, we can go ahead with the construction.
Because we are waiting for the dispute to be resolved, Lordship.
waiting for,
The dispute to be resolved between the landowner and the government, Lordship.
now it is resolved.
They are awaiting the confirmation.
Confirmation,
Yes, Lordship.
what means
We have sent a
it has
proposal
not
to
yet
the
been
headquarters.
reduced into writing.
Yes, Lordship. We have,
It will be reduced into writing, the
Yes,
compromisation,
yes.
not yet done.
Once the payment is released, Lordship.
Payment not yet released.
Yes, Lordship. It is placed before the headquarter for approval, Lordship.
Okay,
Then let them file affidavit, Lordship, by the
Okay.
next day.
the then B has sinking area at chain is 164. That'll be headline, huh? This will be recorded later. Mr. Team Songlan additional AG submitted the matter regarding the lane, acquisition of land has been resolved
So you probably that's.
with the landowner. Mr. Tibi, oh, okay. Mr. Muazzamir, Lana Council for the
NHIDCL.
NHIDCL submits that the compensation has been, okay, submits that he has received the proposal for compensation to the tune of rupees 148 lakhs. Okay,
48 lakhs.
yes, 48. Okay, 48 lakhs, 48 lakhs. And this is with? Okay, and proposal has been made before the headquarter for approval. Okay, and after the which is yet to be confirmed, or what? Okay,
Subject to approval, Lordship.
okay. So the work will be progressed after this confirmation only. How long it will take? Say confirmation. You have made a proposal, probably must have been communicated 2 weeks. So then after 2 weeks, you file affidavit. Yes, okay. Which
They
will-
can file within 2 weeks. Lordship.
which will take further, few days. Okay. Who else will file affidavit in this regard?
The Deputy Commissioner as well as the NHIDCL, Lordship.
Okay, in this
Deputy
regard,
Commissioner Kohima as well as
in this regard, the Deputy Commissioner Chumukadima
Kohima,
and
Lordship. It will be
the
Kohima.
Kohima and the NHIDCL shall file compliance affidavit within 2 weeks. Okay,
Lordship. Then Roman 4, Lordship, with regard to respondent number 19.
yes,
Your Lordship, I have filed my affidavit. Yesterday, I don't know whether it's on.
yes.
Lordship, in the affidavit, Your Lordship, I have given the status of the work in respect of change 164, Your Lordship. Now, respondent number 19 has been engaged. And my affidavit is there, Your Lordship?
Yes,
Yes, Your Lordship. So just relevant page, I'll take Your Lordship to page 3. This is in respect of change 164, and I'm engaged to execute the work of slope protection work, Your Lordship.
Yes,
Page 3, para 4, Your Lordship may come to E, relevant.
yes,
Work could be started on this 21/5/2025, delay in start of work due to delay in completion of excavation for breast wall, construction of box culvert, breast wall, and given wall by another agency. Status of work as on date is 500 square meter is completed. Altogether, Your Lordship, this stretch is 2,000 square meter. Further works of 1,500 square meter is delayed due to continuous rain, surface water flow, and slushiness in this area. Now, as on date, the present status, Your Lordship, 500 square meter I have completed, but F, Your Lordship, completion target I've given Your Lordship, tentative date of completion for balance work by 30th of November 2025. However, Your Lordship, if there are no disruption due to weather condition, then work can be completed by 31st August, Your Lordship.
Lordship,
Yes.
the statements in paragraph E and F can be recorded.
okay. Then the para. Mr. T. V. Jamil, Land Council for the respondent number 19. So respondent number 19 file affidavit, huh? And we have perused the affidavit filed by the respondent number 19, huh? The Mr. T.B. Jamil, Learned Counsel for the respondent number 19, submits that.
Slope protection in GNH 164.
The respondent number 19 was awarded a work for slope protection
Work
staff.
Chain.
Chain is
164.
164. That chain is 164. Huh? The relevant portion of the affidavit, para 4E and F are reproduced here in below. Huh? And that is page 3, huh? E and F. And this is with regards to the slope protection and what else in your affidavit?
No, my respectful submission is after recording this, the direction will be ensured to ensure that it complies within the stipulated time as provided in F.
Yes. In this regard, we direct the respondent number 19 to complete the work as undertaken by
Balance work by 30th November 2025.
okay,
But
by
Your Worship,
30th
if weather condition permits, we will complete it by 31st August.
okay, as indicated in the paragraph 4F by 30/11/2025. Okay. And no affidavit need to file here.
No. not-
Okay. Yes. Okay.
C, Lordship.
Yes.
Unfortunate incident resulting in human casualties. Amicus curiae raises concern regarding an incident on 30th May 2025 between GNHs 126 550 and 126 700 resulting in human casualties. It notes that the incident was reported in the newspapers and questioned how such an incident could happen despite the presence of rock fault barrier. He praised for direction to Deputy Commissioner Chumukitima and responded 19 to file affidavits explaining the incident. Mr. Javier, Learned Counsel states that respondent 19 was awarded work at 6 locations. 5 locations has been completed. The incident occurred at the 6th location between GNH 126 550 and 126 770, which remains unfinished. In this regard, we direct the Deputy Commissioner Chumukitima, respondent number 19 in NHITCL to file detailed affidavits regarding the incident in the current status of work within 2 weeks. Lordship, here I have received affidavit filed by the NHITCL
19.
as well as respondent number 19.
Hmm.
But the DC Deputy
DC and-
Commissioner Chumukitima is yet to file.
Okay.
So we can have a detailed hearing on this unfortunate incident after the filing of the affidavit by Deputy Commissioner Chumukitima.
Whether in this regard, NHI DCL has filed affidavit?
Yes, I have received this morning.
This morning.
Yes.
Okay. Okay.
So let the Deputy Commissioner Chumukitima file the affidavit.
NHI DCL is respondent number 28. Whether we,
Village is in record. Village is in record.
no, not on record, probably. Affidavit is there? Affidavit?
No.
It is
DC, we have not filed.
DC has not filed. NHI DCL has filed. Yes, yes, that is fine. That your affidavit probably covered that also, this point also.
Maybe the registry did not include in the file.
It was not included. Is it there? The latest one filed yesterday. Okay. Bring it.
Dear Lord. Master, can I tell you that?
Yes.
About the incident part.
This one, right? Oh, this person. Probably they have posted to the. What do you have stated here
About the incident.
about the incident?
Lordship, we will get a clear picture about the situation incident only after the Deputy Commissioner Chumukinua file and after.
Right.
So my respectful submission
Hmm.
is that let the short time be given to the Deputy Commissioner Chumukinua to file an affidavit and on the next day can
Since this matter, regarding this matter is also, of course, not very urgent at the moment. So, well, a 1 week time can be given.
yes, let him file, then thereafter, my lord, we can have a detailed hearing on the issue. Without affidavit from the Deputy Commissioner, it will not be possible today, Lordship.
Okay, then C, unfortunate incident resulting human casualties. Headline, As directed, the respondent number 19 has filed affidavit detailing regarding the unfortunate incident. However, the respondent 19 and respondent on 19 and NH 2 and 8 NHIDCL has filed affidavit. However, the Deputy Commissioner is Chumukdima is yet to file affidavit, Mr. Okay, so then additional AG prays for further 1 week time to file affidavit in this regard. The prayer is the AG is granted 1 week time to the Deputy Commissioner is granted further 1 week time to file affidavit, detailed affidavit regarding the incident and regarding the incident. Okay.
May I go to D, Lordship?
Yes.
Construction of Bailey Steel Bridge on 12. May I, Lordship?
Yes, sir.
On 12/3/25, N. Musui, General Counsel for Respondent number 15, informed the court that the work for constructing the Bailey Steel Bridge at GNH 155 has been awarded. Materials and resources have been ordered to commence construction. Mr. Amicus Curie reports that little progress has been made so far. The authority engineer states that although materials are seen at the site, manpower has not yet been mobilized. Considering that the material is already at the location, we direct respondent number 15 to begin construction of the bridge immediately within further delay. My learned friend is here, the counsel for respondent number 15. He has filed an affidavit on this.
Lordship, I've had an affidavit, Lordship. And
Yes.
Lordship, yes, we don't deny the fact that there's been an unforeseen delay in the work. But Lordship, we have already started the construction, the Bailey Bridge. I've
Okay.
stated in paragraph 3 of my affidavit. Paragraph 3, Lordship. Page 2, Lordship. Paragraph 3.
Paragraph 3 or
Yes, Lord.
3 or 4?
3, paragraph 3. So we have already started the work, Lordship.
Okay.
And it will be
So they have started.
So, my lord, let him give an undertaking that he will complete it within the scheduled time.
Lordship.
Okay.
We have already stated in our paragraph in our affidavit also that we'll complete within the scheduled time. Which side? 3.
In this regard,
My lord,
authority engineer also probably in this regard has apprised this court that the material was seen, human power was not found.
but since in paragraph 3, he has
They
given
have
that.
started.
And lordship,
Physical,
bridge has now begun and the seam will be completed on schedule. He has given an undertaking, so let this be recorded.
Okay. D. Construction of Bailey Street Bridge. This is his statement. Whether
Yes.
the,
So let that be recorded. He's giving
Yes.
an undertaking and affidavit that he will complete on schedule.
authority engineer is the person who has seen. So whether they have started, as per the affidavit, they have started. Okay, practical, okay, then it's fine, okay. Okay, in this regard, the respondent number 15 has filed affidavit and has undertaken that undertaken to complete and stated that now they have begun construction of the Bailey Bridge, and the same will be completed on schedule. The respondent has undertaken at para 3, which is reproduced here in below. Stop. The respondent shall complete the construction of the Bailey Bridge on time as undertaken at para 3. Okay.
Lordship E, progress at package 3. The authority engineer reports that approximately 62% of the work under package 3 has been completed. The respondent number 15 is directed to file an affidavit detailing the process, including a bar chart, and to reaffirm that the work will be completed by the end of September 2025 as per the contract agreement. My lord, my learned friend has filed that in the same affidavit, which
Yes,
Is paragraph 4 and 5 also. We have annexed the bar chart of the progress.
Paragraph 4 and
4 and 5.
5.
Yes, paragraph 4 and 5. Lordship, overall, the percentage we have shown is the work completed, not the progress, 70%. Completed 70%, Lordship. But if we could calculate the ongoing also, it will be much higher.
It will
But
be more.
since we have shown a bar chart as per the work completed, Lordship. So as at present is 70%.
Okay.
And
At present,
we
70%.
are within the schedule time, Lordship. We'll complete it within the schedule time.
Now, Lordship, in paragraph 5, my learned friend has been showing some problems with certain changes on 3 locations about the obstruction hindrances by the landowners. But now it is already resolved.
Yes, that's for the.
As per the.
Okay, this was also regarding the lane or
Yes, because my lord, this issue relates to B, the lane disputed. Change 164, now it is settled. So there is no entrance.
Yes. So once the amount is paid and the issue is settled with the landowner, Lordship, we will commence the work, Lordship.
So the difficulties faced by him is already resolved.
This is respondent number 15. Okay, then so here then nothing remains.
So my lord, in the line, my lord, in the line of his statement, affirmation, paragraph 4 and 5, this is the order may be passed.
Okay. The resolution of the hindrance now is
no. Yes, and that also may be recorded that there is no more hindrance.
Okay. What is paragraph 4? It's 70%.
Yes.
Okay.
Progress is 70.
Okay. The now progress of package 3, huh? Progress of progress of package 3. In this regard, the respondent number 15 has filed affidavit in their affidavit at para 4 stated as follows, para 4. So this will reproduce, because 70% they have,
Lordship, yes.
according to them,
Lordship,
70%.
yes.
Milestone is on 10/6/25 has been achieved, and on 14/7/25 progress work is at 73.87%.
Lordship,
In terms of engineering norms, only the completed components are okay, mentioned in the percentage of the work completed. The ongoing and or incomplete component of the work are not included in this percentage, otherwise the percentage would be higher. Okay,
and
and
the
then,
first 4 lines, 5 lines of paragraph 5. He has given an undertaking that he will make shall
okay,
endeavor to meet the set deadline.
so the hindrance
Is
stated in paragraph 5 is no longer,
Lordship,
so now it has been resolved.
Lordship.
Okay. Next paragraph, yes, sir. At paragraph 5, the respondent number 15. Where they have, the date of completion is 28/9.
28/9. 28th of September.
Stated that the respondent has maintained the milestone set in the EPC contract stuff. As such, the third milestone of 70% is on 10/6/2025 has been achieved stuff. The date of completion is 28/9/2025, and the respondent shall endeavor to meet with the said timing. The respondent number 15 has also stated regarding the hindrance with the landowners. However, as stated by the additional AG, as submitted by the additional AG, the matter has been resolved with the landowners.
The NHADC, NHADC.
NHADC, and it was stated by the additional AG that it was resolved.
Both of this.
4 and 5. With this, with the Chinese, oh, no, just a minute, huh? Resolved, huh? The landowners in this, just a minute. Huh? So here, no direction is required.
Lordship,
Okay,
since the undertaking is that,
Okay.
that is important.
okay,
Lordship, they only make an observation that the contractor will ensure that he will complete us per his undertaking.
in this regard, the respondent is directed to shall complete the work as undertaken by 28/9/2025.
Yes.
Okay. Yes,
My lord, F. The last reconstruction, may I read, Lord?
yes, please.
Reconstruction of protection works, clearance of landslides and restoration of damage, section change 172.900 to 185.540. This for my lady, the 4-lane construction ends at Chutuma bypass junction. Thereafter, the remaining 2 lanes falls within the national under the jurisdiction of the state. So this is the issue that all of us has traveled the other day. So may I, Lordship?
Yes, please.
Amicus Curie highlights that Kohima is the capital of Nagaland. Improper maintenance of the road from Dimapur to Kohima is essential to the state's development. Failure to maintain this street which falls under the jurisdiction of National Highway Division, would undermine the entire 4-laning project. Respondent number 20 was awarded work by the Ministry of Road Transport for reconstruction, repair and landside clearance at NH-29 under the special repair scheme for 2024-25 with a sanction amount of 1.98 crore. The work has been reportedly completed and the completion certificate was issued on 13 March 2025. Amicus Curie questions the status of the work as there is no visible evidence of completion. AG explains that the work was non-bituminous and was damaged after the completion certificate was issued. He further submits that the ministry has now sanctioned funding for bituminous work. The learned AG placed a document regarding the estimate for the work which reads as under. The relevant estimates indicates a sanction of rupees such and such for improvements from such and such under the Nagaland National Highway Division. The government states that despite damage after certificate was issued, he will manage the work, and as the ministry is now already sanctioned. In this regard, the responses number 4 and 5 are directed to file a detailed affidavit within 2 weeks explaining their proposed approach to completing the work, including the damage portion. So far, I have not received the affidavit.
Here, in this regard also, we have not filed affidavit.
Lordship, we have not filed the affidavit, but regarding those, the coverage, that is a change 172 to 185, that is Chusuma Junction to Lidike. So we have received a sanction. We issued we have already loaded the tender. We shall be completed on 30th July 2025.
Lordship,
But in the meantime, Lordship, we will allow to file on the next step.
There is an urgency because since the last hearing, the route has gone from bad to worse.
Yes.
In fact, for several weeks, even the traffic has to be diverted because it was not pliable. And as per the report, again, some landslide has occurred recently.
Yes.
And so, my lord, unless and until the state government takes serious note of this,
yes,
we'll have the general public will shall continue to suffer. So let him file an affidavit immediately within a week's time. Also, Lordship, a specific direction should be given to the respondents for maintenance of the road at least so that the road is made pliable. In fact, a viral video was widely circulated where the military personnel were even finding difficulties to ply their gypsy. If a four-wheel vehicle is not able to ply because of the mud. So, my lord, some direction has to be given so that by the next day, some improvement should be there on the ground.
The maintenance is from the same fund which was granted, or?
My lord, it is the bonding duty of the state government to maintain at least the road, at least the issue. Lordship, what prevents them to bring some jeeps or some stones and maintain the road?
Right. But if the road has been given to the contractor, does it cover or it is the government?
My lord, they are saying because last time the work 1 crore 98,000.
Yes.
This issue was raised on the last occasion. My submission was that, if your lordship recollect, on the first rain,
right,
in the pre-monsoon, everything was washed away because it was only mud. That was the discussion the lordship remembers, and this honorable court was questioning when the court is in session of the matter, how the completion certificate was issued by the engineer without permission of this honorable court. I was really serious objection to that. Yes, it may, lordship.
Yes.
Now it is the boundary duty of this government state government to ensure that at least minimum maintenance is to be given.
Yes.
Because
the road is used by the government
after the rain after the monsoon only. Whatever sanction order has come, very good. But till then, we shall the
state should maintain.
State should maintain. Without maintenance, lordship, and
yes.
Because it is admitted by the government, considered by the government, that whatever little construction has been done is all washed away.
Yes.
And all of us are sent on the ground. We don't need any other experts to go and see the area.
So, some direction to be to
Yes,
the state
let the
to
state
maintain properly, because the state is the one who use the roads mostly.
Besides Nagaland, lordship, this is a lifeline from Manipur.
Right. We'll reiterate this order, and at the same time direct the states to properly maintain.
Yes, and On the next day, Lordship, besides the direction given on the last occasion, Lordship, let them file an additional ground. The action taken report on the maintenance after the direction from this honorable court on the next day. What action taken on the ground after direction from today by this honorable court for maintenance? Some progress will be there. Otherwise, Lordship, the direction of this honorable court, if you don't respect in the affidavit, the action taken report on the maintenance also should be there.
Who is respondent number 20? 20, okay, that one, yes. So that was washed away.
Lordship, they need to be filed by respondent number 4 as well as respondent number 4 and 5.
Yes.
4 and 5 is the commissioner's.
It was directed, we will reiterate the same order and then with the direction. You already plotted tender. Okay. Then
This for all streets.
F, reconstruction of protection works, comma, clearance of landslide, comma, and restoration of damaged sections. Chain is 172.900 kilometer to 185.540 kilometer. Okay. In this regard, the land regional AG submits that after after receipt of the sanction from the ministry, the state has already floated tender for what?
Improvement.
Improvement. And
That's a winter notice. Everything is.
can you just? Has floated tender. For one-time improvement of NH 39 within bracket old from kilometer 172.900 within bracket Jotsoma bypass junction bracket close to kilometer 185.540 within bracket Larry welcome gate bracket close length within bracket length colon 12.64 kilometer bracket close under PWD NH division 1 Kohima in the state of Nagaland. On 24/6/2025. Mr. Takamasa Land Council, Land Amicus Curiae submits that over the period, there has been a multiple landslide in the area, which requires immediate repair and maintenance of the NH 39.
The particular portion, Lordship, that is
okay. In the NH 39 portion is 172.
172 to 185.
Okay, from kilometer 172. 900.900 to kilometer 185.540. Still.
This is one time.
The. No, no, on the- on the- Yeah, proceeding is very close to- Same. Accordingly, the state is shall is directed to maintain the road. Stop, and the state, the respondent number 4 and 5 are also directed to file detailed affidavit,
Including the action taken for maintenance, Lordship.
and also regarding the action taken on the maintenance within 2 weeks.
Lordship. Finally, Lordship,
Okay, within 2 weeks, huh? Okay, yes.
my lord, because of the rain, in many areas there has been landslide and road has been damaged. So since the authority engineer is here, Lord, let him highlight the position on the ground. And Lordship, a direct observation or direction may be given to the NHITCL to ensure that road is properly maintained in all those places where there are landslides and
Yes, sir.
sinking area
The-
portions, damaged portions.
Yes.
Let him highlight the position.
The state was also in the last occasion, the state was also directed to file, cover the damaged portion also.
Yes, but they have not done anything.
No, no,
So that may be reflected in the Lordship's order.
yes, so what could be done or what? Yes.
My lord, during the days 5, 6 and 7, due to heavy rainfall, in package 1 and 2 alone, there were about 30 landslides. Some were minor, some were major. And in one location, the road was also blocked for about 2 hours. We could reopen the road in 2 hours. And 2 lane was restored by that evening itself. Now, out of this 30, about 12 were completely removed. Remaining removals are under progress. But 2 lane traffic is flying all across the road. There is no entrance for 2 lane traffic. The landslides removal is a continuous process. We have engaged our contractors. They keep on removing the landslides from wherever it occurs.
Okay, so now what is to be done to protect?
Regular maintenance only.
Regular maintenance.
That is under process. Contractors are already engaged.
The one side is totally unusable, cannot be used at the moment.
Because it's the safety risks are there. Even though we are removing the landslides.
So that it appears that also has not been removed, most of them.
Even though it is removed, there is a chance for further landslides in some locations. So we are restricting the traffic only through whichever is the safe 2 lanes.
Okay, so now your target is to protect these 2 lanes.
Yes, 2 lane is completely under like pliable. Traffic is flying through 2 lane. And whenever there is a landslide occurs, we are keep on removing that. It's a continuous process, of course. That's the status of the road.
Let that observation let his submission be recorded with an observation.
Okay,
by the son of-
your submission will be recorded, huh? Okay, Mr. George, authority engineer submits that. There was a massive landslide during 5, 6 and 7 of July.
Yes.
Okay. And in many portions, there has been a landslide.
He's saying
And
30.
it is under
30
continuous, it is under continuous maintenance, huh?
Well, he's submitting that there was 30 landslide out of which
Package 1 and 2.
in package 1 into 30.
Locations, 30 locations.
Okay, landslide in 30 locations. Okay. However, the maintenance is going on. Maintenance over the said location is in continuous process,
Issue.
continue process, which will continue. You will continue it.
Yes, sure.
So 30 location, how, 30 location, it also, the landslide is also in these two lane where the road is being used.
No, slightly it was affected, but immediately we removed that. And the
Okay.
2 lane is completely under operation.
And due to the removal of the landslide, the 2 lane is now playable.
Yes.
Lordship, a direction will be issued
Ah,
to any citizens
okay.
for prompt maintenance
Hmm.
in future.
The landslide during the monsoon is a continued process. The engineer, the NHIDCL shall continue maintaining the road so as to enable the, for making the road playable, huh? Okay. So no need to file any affidavit
Sorry, Lordship, that
in the,
observation is
regarding this
sufficient for
point.
that. Yes.
Yes,
May I
sir.
mention, it's, nodal officers is present through the VC on the, in this matter.
Okay, no, nodal officer is directed. Okay, he is present.
Yes, through VC, sir.
Okay, so his
RPC.
presence is,
Because earlier occasion, Lordship, there's a direction that
Yeah.
nodal officer to be present on all occasions, so he's
Okay.
present, that's it. No problem.
okay. The nodal officer as directed is also present today.
Lordship.
Any, whether, you have, do you have anything to say?
No, sir, my people have already told, sir, I
Not
agree with
audible.
you, sir.
Lordship, to be marked the present.
Hmm?
To be marked the present.
Yes, yes, present. Directed. Damage portion. Covering the damage portion also. Then, huh? No, they've sought for time. We'll give it.
Lordship, and then
So-
you fixed. After 2
Yes,
My
so
lord,
on the respondent number 4 and 5, while filing affidavit, you should also cover including the damage portion also,
Yes.
regarding the damage status of the damage portion also. Okay, and then keep on maintaining the road. So direction also will be given to the NHIDCL also for proper maintenance of the road, so as to make the people pliable.
My lordships, I'm appealing for the respondent number 20.
Okay, Mr.
My lord, I pray that the respondent number may be dispensed because the work which was given to the.
Now, on the next day, we'll dispense your presence because now they will file affidavit. They have not yet filed affidavit. After the filing of affidavit,
Yeah.
20 will be dispensed
Yes.
probably. Because they said that they have done it and then it was washed away
Yeah.
subsequently.
Yes.
Okay.
Lordship, and then will be fixed.
Okay,
Let it be after 2 weeks.
Okay,
so
let the
that,
matter be
we
listed.
can't have it.
again on. It will be,
A witness after 2 weeks, Lordship.
so after 2 weeks would be 30,
Lordship.
30,
1-3
3,
or 3-0. Okay.
30 or 13, 30 or 6 August.
Let it be 6.
6 August, okay. And then the presence, just a minute, huh? Same, the nodal officer shall remain present in court on that date as directed earlier, huh? Okay. And then the present, let me just record, huh? In the beginning, Mr. Takamasa, learned senior counsel, who is also the learned amicus curiae, huh, staff. Also had Mr. M.T. Imsong, learned additional advocate general for the state respondent number 3, 4, and 5. Mr. T.V. Zamir, learned counsel for the respondent number 19. Mr. Longkumar is for 20,
Respondent number 20.
20, Long Kumar, Line Council for the respondent number 20, and Mr. Muazzami, Line Council for the respondent number 6, 7, and 16. And also Mr. George, the authority engineer, NHIDCL,
And
is
Mr.
also present.
Respondent.
Oh, more, sorry, Mr. Mojo,
Respondent 15.
for respondent number 15, huh? So 20 in the last, huh? Because as per the serial of the 20 would be in the last. Okay.
Much obliged, Lord.
Okay.
For admission, item number 4.
After we have filed our affidavit, Lordship, we need some more time to reconcile with the government, of course. Can you see the order 4, 6, 5?
Yes.
It's just direction, we give it to me. It's one of the 5. To sample all the claims of the hospitals and other hospitals. And to find an affidavit. Today.
Yes.
Today.
Now, there have been some issues with, they have filed an affidavit of sale. I received on for the evening. So I need some instruction as far as the statement made constitute. Because the figure that has been shown, it's not tallying with the our figure.
Figure shown by?
FJ, number 5.
Okay. The respondent number 5 has filed.
16 July.
Yes. Four not yet filed. You are 4?
I have 5. Respondent number 5.
You have filed. Okay, file affidavit. Okay. And what about the 4?
If my lords may please allow me. The respondent number 5, they have filed their affidavit in compliance to the order passed by the Honorable Court.
Yeah.
However, since they are saying that a certain amount of the claim has already been settled, then which claim, there are so many claims that has been submitted to them. The affidavit has no clarity. There should be a clarity for which claim and for which hospital, which amount has been settled. And the total, the specific has to be brought on record in the affidavit. If not, if it is paid in parts and then there is no specific mention of which claim has been settled, later on after the litigation before the Honorable Court also, there will be further litigation. So my lord, there should be clarity in the affidavit. And there are some clarifications to be made that I have to seek clarification from my clients also, but as far as the present affidavit is concerned, there should be clarity on which amount and for which claim it has been settled, my lord.
So
Certain things.
settle all the claims filed by the members entitled.
Lordship, 14 claims are pending, shown pending, Lordship.
See, para 3, respondent number 5 has settled all the claims filed by the members entitled. Member entity source. Represented by respondent number 6. Okay.
Paragraph 4 speak about completed payment of what admitted. So they cannot say that they have cleared all the claims. In paragraph 5, they are saying for the admitted claims. Now there are some issues with respect to this website also, Lordship. May please come to page 5, Lordship, of my application. Annexure A, page 5. Lordship, here.
Annexure A.
Yes, Lordship, this one.
Yes.
Here the total claim pending is shown 0. This is a portal. That is the portal where we need to file our compliance and all, Lordship. Because this is a portal used by the National Health Authority, NHA. So their claim is that the claim shown is pending is 0. But we are saying no, it does not carry that.
It's no, it does not have. Okay.
The set authority.
Now your prayer is?
They should come up with the clarity.
Okay.
And we need some more time also, Lordship, because see the next page, Lordship, that is page 6. Total 14 cases are shown pending, but that is not accessible from our system, Lordship, in the portal. So we have mentioned that thing also. So they will clarify by consultation with the NHA.
If I may, Lordship,
Yes.
Regarding the claims that have been paid, and as mentioned in the affidavit, at page 3 of the compliance affidavit that has been filed by the insurance company, which is the respondent number 5, Your Lordship, they've mentioned that a claim of about 44,789. These claims have been admitted, and those are clear. But Lordship, however, if we go to Annexure A, which is at page number 5 of the compliance affidavit, here again, the claims approved shown is again 47,139, Your Lordship. So there are conflicting figures and statements, and as respondent number 6 has clearly mentioned, until unless there's clarity given categorically on this hospital, this much claims have been received, this much has been approved, this much has been not approved on whatsoever grounds. So all these things in clarity has to be mentioned. Just merely stating figures and numbers, there's so much of confusion that's happening in the process of the spending PI, Lordship, and some sort of clarity has to be given. Figures are not tallying as per the annexure and as per the statement made in the affidavit, Your Lordship. So this constant confusion, chaos has to be cleared within so that there's a final clarity.
So they filed this affidavit based on the portal only. So how do they get?
They have
that?
the system. They have their own system.
They have own system.
Yes. Now claims are paid by the insurance company to the contractor hospital. They pay, not us.
Okay.
We pay our premium to the insurance company. The insurance disperse the pays. So it's there in the system.
It should based on the system they maintained.
Yes.
Yes, Your Lordships, it is their system. So we do not know, I'm representing the independent private hospitals. We do not know for which claim that a payment is made to us. So everything is at 6s and 7s, Your Lordships. And that clarity has to be given by the insurance company, Your Lordships.
Now, okay.
But this is the web portal of the government, Lordship. Here the claims are shown as 0. Page 5, that is the web portal of NHA, National Health Authority, Lordship. Here the claims are shown 0. There is some issue with the website also that is being admitted by the government, Lordship, because we have a meeting recently, just last Friday. The government has also accepted, yes, there is some issue and they will consult it with NHA and they will inform us, Lordship.
Consult it to the, consult it to the?
NHA, National Health Authority.
NHA.
Okay.
So the main portal is made by the national. So that's how they are accessing, they are extracting the information from the National Health Authority portal. So, but however, Lordship, as already pointed out, the statement in the affidavit and it should tally with the.
Yes, yes.
In the statement, they're saying 44,000. Whereas in the portal is shown as 47,000 again. There's a vast difference of 3,000 plus. So they should come.
Is the portal only way to know?
Yes,
is
Lordship.
this, but system is being maintained by you only?
We have our own system, but we have to upload all the details in the portal, Lordship. And that is why the portal is showing as claim for.
How this can be resolved then? In that, so that they get
come
the
up
correct
with a
figure.
resolution.
Correct figure.
Only the government, as far as that part is concerned, I have not received the instruction as now, Lordship. But I've been informed that the issue has been raised to the National Health Authority by the State Health Authority. So that the number tallies, the claim tallies.
Issue has
But
been
that-
raised, but
That is with regard to the number of claims, total number, not with the segregation of hospitals. Segregation will be.
now see the affidavit, what you have stated in the affidavit and the portal which shows in annexure also, this also doesn't tell you.
As far as since the NHA, the Ministry of Health and Welfare, they are presented by the council. So if some certain direction can be issued to the National Health Authority to resolve that issue. Because as per what my learned friend has shown in the last meeting, because I was not aware of that. It was held on 11th.
11th. That's last Friday, Lord.
Last Friday. So some issues have been raised by the AGI also.
Most of the claims are not accessible in our system also, Lordship.
They are not able to access, that's what they are saying. They are not able to access the portal of the NHA. So that's how some claims are still like pending. But in the portal is on 0 day.
Now, because the system is with you, as well as you are also accessible.
System is maintained by National Health Authority.
Okay. Now, how this can be resolved? What we are querying is.
We have argued.
How this can be resolved?
That the.
Because-
State Health Authority has written to the NHA
Hmm.
to resolve this issue. But we have not received any positive response from the NHA. So if NHA may be directed, the National Health Authority to resolve the issue.
Last Friday.
You have to properly maintain the data in the portal, because this has to be resolved. Unless it is resolved, how the correct figure will come and how they also will come, the object.
The Lordship,
this will-
it has to be
yeah,
understood in parts. The one part is they are maintaining the record and they are uploading in the NHA portal, the insurance company. As far as the breakups are concerned on which case has been rejected, which claim is accepted, and how much payment is made for which claim and which hospital, that record is with them. They should also annex their records of payment of the claims by way of in the affidavit, Your Lordship, not just relying on the NHA portal and then the confusion which the Learned State Council has already stated. Now that clarification is under process. But as of now, what has to be firstly understood is which are the claims that they have rejected, which have been accepted, and how much payment has been made for which claim and which hospital. That clarity has to be shown in the way of affidavits, Your Lordship.
That has not been shown here in this
Yes,
affidavit.
Your Lordship.
No, no, it's
It's
not.
not exercise.
It's a shortage.
Regardless, Your Lordship, big or small, it has to be
It will be a huge
black and
exercise.
white, Your Lordships.
44,000 claims, Lordship. It is shown here 47,000 claims.
Now showing entire those things, you have to file, I think, the affidavit. Proper affidavit covering all.
Yes, my lords, they don't have to produce everything,
Yes.
just the name of
Make
the
the list,
hospital.
make the list.
Yes, Your Lordship, the list itself is enough.
Make the list so that they comes to know that which one is was accepted, which is paid.
Lordship, if hospital A has got 10 days,
Hmm.
he is qualified, then this 5 is rejected. Then that will show the clarity also.
Okay, Mr.
A Kakoti.
Just a minute. Yeah, Miss. Miss.
Miss KKK, Your Lordship.
KKK, Land Council for the petitioner. Also had Mr. M. Tim Song, the Land Additional AG for the respondent number 1, 2, and 3. Mr. Mojoifo. Mojoifo, standing counsel for the respondent number 4. Mr. Joshua Seki for respondent number.
6 months.
Okay. A Kakoti is for respondent number 5.
Five.
Oh, Mr. A Kakoti, Land Council for the respondent number 5, and Mr. Joshua Seki, the Land Council for the respondent number 6.
5 for 7.
Okay. Mr. Yangarbati for Yangarbati Land CGC for the respondent number 7. Stop. The respondent number 5 has filed affidavit. The compliance affidavit. However, it is submitted that the said affidavit doesn't cover the the figure in the affidavit is not tally with the portal, nor it covers the entire details as to whose application or what application is rejected or accepted.
Yes, Your Lordship, claims.
Claims has been accepted or rejected in respect of which hospital.
Yes,
Okay,
yes,
stop.
Your Lordships.
The
Well,
so then they'll have to file
a comprehensive affidavit.
comprehensive affidavit showing the entire detail.
Entire detail.
Category, Lordship.
Total claims made to particular hospital and claims denied to particular hospital.
Okay, in this regard, the respondent number 5 shall file a comprehensive.
My lord, breakup amount also has to be shown in the comprehensive affidavit.
Comprehensive affidavit showing what?
Breakup amounts for claim specific and hospital specific. There are many
Also,
claims, claim specific and hospital specific.
Showing the
my lord.
claims specific and hospital specific.
My lords.
Okay. And
Respondent number 7 may also be directed to
Clarify.
clarify on the portal, Lordship, because we are
Okay.
facing the issue with
the respondent number 7 shall also clarify the portal incorrectness of the portal. Okay. So by way of filing affidavit.
If needed.
Okay. Filing affidavit, okay. By the next date? Okay.
Last week, August.
Thereafter, after clarification only it can proceed.
My lord.
Thereafter only it can.
Yes, your lordship.
Okay. But within 2 weeks, we'll say within 2 weeks. you
Lordship,
file
some
affidavit
time, maybe
within
some more time, maybe
3 weeks, 3 weeks.
Put it in August last week, Lordship.
No, you
Because
file
it-
within
it is a-
3 weeks. We'll fix it on August.
27th. 27th August.
August. When?
27 August.
27 August.
That's what I saw.
Okay.
So within that time. we
Okay,
have-
then, as prayed for by the non-council for the parties, let this matter be listed on 27 August. In the meantime, the respondent number 5 and 7 shall file affidavit as indicated above. Okay.
Four and five.
No, 5 and.
5 and
7, 5 and 7.
You're correct, your lordship.
5 and 7.
Even I was directed to find the affidavit also.
Or 4 also.
You are 4.
Four.
Yes, yes, 4, sorry, 4.
4, 5 and 7.
4, 5 and 7.
Lord.
Okay.
Lord, your lordship.
Affidavit may be filed by 20 or 22nd
Okay.
August.
Lordship, if sufficient time can be given so that
So
to
that
compare
we are
the
fixing it on August
August 20th, but they're saying to
27.
file it by 20th of
So,
August. but
affidavit.
Try to,
Okay, we'll say till then.
Till.
Till then. During this period.
Lordship.
Okay, we'll say during this period. Okay.
If they can file before 20th August.
Lordship.
Okay,
Before the
affidavit-
20th, so that
affidavit.
perusal can be done on the
Yes.
affidavit file.
Respondent number 4, 5 and 7 shall file their affidavit on or before
Yes.
the 22nd of August. Okay? Okay.
Obliged.
Grateful Lordship.
All right, item number 5.
No.
Yes, Yangarabati.
Yes, as per the order dated five.
Have you filed?
Yes, yes, I have been deliberately informed that the stretch from Bimlai to Momsati has been included in the tender.
Yes.
But I have been specifically informed by the ministry that the stretch from Bimlai to Momsati has been included in the tender. But I have not received a hard copy. On the last occasion, Lordship, the Honorable Court by order dated 14/5/2025. Order dated 14/5/2025. Lordship, may I see the last paragraph of the order, page 4, the operating portion. Mr. Yangarwadi,
Kara,
page 4,
page 4,
page 4 of the order.
order dated 14/5.
Yes, Lord.
14/5, my lord.
There is no
14/5.
page 4.
The last page of the order, 14/5/2025, last page of.
Yes, yes.
The last page of the order, my lord.
Yes.
14/15.
Hmm.
So
The second last paragraph, Mr. Yangarwadi.
Yes.
The CGC.
Next date come with the instruction is to widen the stretch of road. It's not been included. Okay, why it was not been included? You
Your
have not
Lordship, I have been
received-
delicately informed that that particular stretch has been included in the
Included.
in the tender, but I do not have that hard copy of the
Hard
order.
copy. So you file an affidavit,
No, Lordship, I have not
bring
received
it
the hard
on
copy.
record by file affidavit.
Okay. There is,
When-
I have not
when it is
received the copy
expected-
of the hard copy
when
so
you are
far.
expected to receive the hard copy?
By 2 weeks. Within 2 weeks, I will file.
2 weeks.
Yes.
You are yet to receive the copy and then you have to file affidavit.
After I received the hard copy, Lordship. I was informed telephonically that the
Okay, Mr.
Your Lordship, I'm for extent respondent number 2, 3, 4, and 5.
Okay.
We were entrusted this work of the NHITCL in the month of May 2023. Accordingly, we have put up our proposal for allocation of fund in the month of September 23, 2023. And because of the last Lok Sabha election, fund could not be allocated. Otherwise, the state government is very much ready to maintain the road in the traffic worthy condition. That's our submission. We have already filed our affidavit on 10 September.
You have already filed?
2024. Yes.
And, okay, we gave the same statement.
Yes.
Okay. Ms. Rosino, Land Council for Education. He has been instructed that. Yes, received. No, received only hard copy is available. Also had Mr. L.T. Sangtam, Land Additional AG for the state respondent number 1, 2, and 3.
2, 3, 4, and 5.
And 2, 3, 4, and 5. Okay, Mr. Muazami for respondent number 6 and 7. Joshua Saki for respondent number 8.
My lord.
And Mr. Yangarwati for
1.
Respondent number
Okay,
1.
Yangarwati first, huh? Then CGC for respondent number 1. Stop there. Mr. Yangarwati, Lanet CGC for the respondent number 1. Some state. The notice inviting tender dated 8. No, it was included in this 8/11/2024. It was not here. You said that it was included according to your information.
Yes, it was by information.
Instruction.
Lordship, it was
It
by
was-
information only. I do not have the hard copy, so I cannot.
No. So according to your instruction, the stretch of road, NH 29, stretch from Pimla to Namsti also
Yes.
included.
Has been included the tender.
In which tender?
My lord,
No.
my lord is correct. As far as that information is concerned, it was not included. That's why we have questioned.
Yes.
Yes.
And that is
That
the
is why-
reason
that
why
is why
this
I'm asking.
clarification is required.
That is why we are asking in which tender it was included, because it on 8/11/2024.
Lordship, that is by telephonic information only. I do not have the hard copy, so I will be given some time to.
No. After seeing the tender dated 8/11/2024. Only since it was not covered, that is why they raised.
Yes.
this-
Yes. In the first tender, it was not included. In the first tender, that particular stretch was not included.
There was a second tender also.
No, after the query from the order of the order court, the ministry, they have included the particular stage. But I do not have the copy of the order, hard copy of that order.
Later on, it was included.
I was informed. I do not have the copy, Lordship. I was
No.
informed.
So see,
That is why,
in the
Lordship.
technology, you could have received from mail also, WhatsApp also even.
Yes, I have not received any mail, Lordship. Only it was by that telephone.
Some state, the stretch from Pimla to Namsi has been included in the subsequent tender issued by the ministry.
Yes, Lord.
However,
I have not received the hard copy.
he is yet to receive the hard copy of the said tender. Say the inclusion of, okay, say tender, huh? Say subsequent tender. It the same tender or subsequent tender?
It was a subsequent tender.
Subsequent tender.
Yes, yes. So let me
Is
give.
it possible?
No, that is my lordship. Let this matter be listed after 2 weeks. So after 2 weeks, within that time, I can file my affidavit also if necessary.
Your lordships, as on today, we cannot comment because it may be in the form of corrigendum.
Yes, lordship.
Corrigendum.
So 3 weeks time, lordship, and in the meantime, I will take further steps.
Okay. They will pray for some time, 3 weeks time, to obtain necessary instruction in this regard.
Yes,
And also to obtain, in this regard, and to also to obtain the hard copy of the tender, including the stretch from Pimla, whereby the stretch from Pimla to Mainam C has been included. Okay, stop. The prayer is allowed. The NSCGC is granted. How much time?
3 weeks, lordship.
3 weeks time to obtain necessary instruction, including hard copy, and to file in and then place on record in affidavit by filing affidavit. Okay.
Lordship.
List this matter again.
After 3 weeks.
After
3 weeks.
After 3 weeks. Okay. Okay.
For orders, item number 7. May
So-
yes, Lordship, I have sought time for listening the matter after 1 week on behalf of my colleague.
You want to file objection?
No, the thing is, my colleagues handling the case.
No, this is appeal. Appeal only. Appeal against conviction.
Yes,
Whether the state would have objection
to the condemnation of delay. Lordship. There's a condemnation of delay. As far as that is concerned,
delay condemnation.
This is
Services.
Whether the service is complete.
My lord, on the last occasion on 18/6/2025, the service upon response number 2 and 3 were served through the Leonard BP to be routed through the OC of North Police Station, Kohima.
Not on record, office record also not.
That was the order, Lordship.
You don't have instructions.
not yet, not yet. We have not yet received
any-
this instruction. So if the matter may be listed after next week.
So the private respondent also need to appear,
Victim.
victim. So what to do? You want to take fresh steps or what?
No, my lord, the direction was, the last paragraph of the order was that after service of notice by the Leonard BP through the OC,
You get it?
the OC has to file a service of notice receipt, Lordship. We can, Lordship,
Office note also doesn't reflect anything about regarding the report. Service of report, huh? Notice upon the respondent number 2 and 3.
Lordship, let the Leonard BP get instruction on the next day.
You get instruction?
Yes, yes, Lordship.
Okay. Add Mr. Tosi Longkumar, line counsel for the applicant. Mr. You are appearing on behalf of Mr. Angami?
MS Mere.
Appearing on behalf of Ms. Mary Lana PP.
Conviction is under POCSO.
Yes, Lordship, conviction and something. Section 6 of POCSO Act.
Praise for Father, 2 weeks time. You see, do you have any instruction to file objection?
I don't know that. But I've not instructed.
Okay, okay, okay. Instruction regarding service of notice upon the respondent number 2 and 3. Okay, list this matter after 3 weeks.
Lordship, maybe it may be listed next week. Because.
Next week?
Yes.
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 No, list this matter after a week. Okay, we'll say.
Obliged, Lordship.
For orders, item number 9.
Lordship, I'm appearing for the repetitioner, Lordship. Here, Lordship, the matter relates to choice posting. But the man has already been posted to. Am I audible, Lordship? Lordship, the
Not
matter
audible.
relates.
You are not audible. Land Council, you are not audible. Return service is still awaited.
Lordship, the matter has become infructuous. Matter has become infructuous, Lordship.
No, not audible.
Lordship, the matter has become infructuous.
Oh,
Matter has become infructuous. Infructuous, Lordship. The man has been posted to Lucknow and he has also joined at Lucknow. Matter related to choice posting.
Lordship, may I please?
Yes.
I am the assisting local counsel.
You are assisting?
Yes, Lordship.
Okay.
Lordship, the matter has become infractious.
Okay.
While the notice is awaited, we have received a copy of the order from the respondent, whereby my choice of posting has already been granted.
Okay.
So the matter stands infractious.
Okay.
If I may place this order before your Lordship.
Mr. What is his name? He is the main counsel.
He is the principal counsel, but however, his name is not reflected in post
Okay,
list.
you are Mr.
Aliba Uzkum, Lordship.
Okay, Aliba Ozukum, who submits that the matter has become infructuous in view of
My name is featured as serial number 1, Manoj
Okay.
Charosia. So I have been
This
posted to my choice of posting.
is close on becoming infructuous. Okay. Okay, then. Oh, your is number 1, A.
Yes, Your Lordship.
Okay, okay, Mr. Huh? You are Mr. Aliba Ozukum.
Yes,
Land Council for the petition submits that the matter has become infructuous as the petitioner has been posted in the place of his choice.
His choice of posting.
His choice of posting stuff. In view of the above, this petition is closed on becoming infructuous.
Obliged, Lordships.
Obliged.
For orders, item number 10.
May I please, Lordships?
Yes.
The IA 110 has been filed for continuation of delay of 197 days in preferring the appeal.
Okay. Police notice.
Yes, sir.
Mr. N. Longkumar, Land Council for the applicant. Stop. This is an application filed under Section 5 of the Limitation Act 1963, praying for condonation of delay of 197 days in filing the connected writ appeal. Stop. Issue notice. Stop. The petitioner, the applicant shall take steps upon the respondents by a registered post with AD as well as by user.
My lord, I have served a copy to the caveator. They have filed a caveat. So I have served.
Caveator is present.
The caveator is Muad Amir. So I have already served a copy to the caveator.
And Muajamir represent all the respondents.
Only one respondent, my lord. Only one respondent.
Okay, petitioners are 3. Okay, so respondents. Issue notice. He is not present today.
He was present.
Then counsel for the applicant submits that he has already served copy.
State.
State. Yes. Submits that he has already served copy to the caveator. Counsel for the caveator, Mr. Muazzamir. Then let him be present then. Let him be present, he might file objection.
Yes, yes, yes. So a date may be fixed for that.
Okay, let this matter be listed. After a week,
Yes, my lord.
after a week.
Yes, my lord.
For hearing item number 11.
Lordship, I'd like to mention this item number 12. So most probably item number 12. It has come after 2 weeks, Lordship, of item 12.
3 weeks.
After 3 weeks, Lordship.
You are for?
For the union, your lordship,
For the union, Lordship.
the Ministry of Human Resources.
You're seeking adjournment.
Yes, my lord. Because it appears the item number 11 will take some time.
Okay.
Not only that, your lordship, my learned friend is yet to file an affidavit that has been directed by the Honorable Court on the question of the equivalence of the Hindi graduates and the secular graduates, your lordship. So
Yet to file affidavit.
yes, your lordship.
Not
The
yet.
equivalence that we are asking is to apply for Hindi job, not for others, but then by the order of the Honorable Court, that clarification was so is yet to file that affidavit.
But it is in the hearing list.
Yes,
But you are yet to file
in the
affidavit.
hearing list, Lordship. We have not filed our affidavit. It's
Clarification has been sought.
clarification from sought
Yes,
on the court. Where-
Clarification sought by the court.
Yes.
Yes,
where-
your lordship.
Okay. Mr. Yangavati, Lanet CGSC, submitted is sought by the is clarification sought by the Lanet Council, by this court. He is yet to file affidavit
Yes, my lord.
and therefore pray for some more time. Okay. To which Mr. Joshua Sekilan, counsel for the petitioner, has no objection. Accordingly, the prayer is allowed. List is met after
3 weeks.
3 weeks. Now, in the meantime, the respondent, CGSC, the CGSC will file affidavit.
My lord.
Compliance affidavit, that means. Is it a
Comprehensive affidavit, Lordship. Comprehensive
Okay,
affidavit.
compliance affidavit. Okay.
My lord.
A comprehensive affidavit.
Yes,
Okay, comprehensive affidavit. Okay.
My lord. Oblige, your lordship.
Okay.
May I please, lordship?
Yes.
Before my learned friend makes his submission, I may be allowed to make short submission before your lordship.
Yes.
Now,
You are for?
here I am appealing for response number 2 to 5, your lordship.
Respondent number 2.
2 to 5, 2,
2
3,
to
4,
5.
2 to 5. Now, may I take your lordship to page 382 of the appeal memo? 382. This is the judgment which is under challenge. 382.
The petition of the appeal.
Yes, lordship.
380 of the petition.
Yes, 382. This is judgment dated 26/9/2024, passed in writ petition 317 of 2023, which is under challenge in this appeal.
387.
382.
82.
382. The judgment starts from here, 382. Lordship has got it?
Yes, yes.
Yes, this is writ petition 317. Now, may I take your lordship to relevant page 387.
Yes.
387, this is the date, judgment date, 26/9/2024, your
Yes.
lordship. Now, 388, para 5. May I read out?
Yes.
Mr. Samdam Lerner, additional AG, Nagaland, representing the response number 1, as well as Mr. Jamir Lerner, counsel representing response number 2 to 19, have submitted that no counter affidavit on behalf of the state respondent has been filed in this writ petition, as in the batch of writ petition involving similar issue, writ petition 189 to writ petition 199 of 2020, a comprehensive affidavit in opposition on behalf of the state respondent was filed, and the stand taken in the said comprehensive affidavit in opposition would also cover the issue involved in the instant writ petition. They have submitted that the said batch of writ petition number 189 of 2022 to writ petition number 199 of 2022 was disposed of by a common judgment order dated 29/2024. Your Lordship, now, Your Lordship, against this common judgment and an order, Your Lordship, dated 29/2024, Your Lordship, an appeal has been preferred, which is now pending before the principal seat, Your Lordship. Now, in the issue.
Again, this 20.
Yes.
9/2024.
And then it was listed on 27th of June, 2025, Your Lordship. And writ appeal is numbered as writ appeal number 3200/2025. Writ appeal number 3285/2025. Writ appeal number 3321/2025, Your Lordship. Now, of course, in that connected appeal, Your Lordship, there is a condonation of delay. So on 27th of June, 2025, notice only has been issued, Your Lordship. Like, I'm just bringing to the notice of Your Lordship. Now, since this, the judgment order based on which the judgment which is now under challenge has been passed, Your Lordship. Whether it will be appropriate for this, Your Lordship, to take up. I'm just bringing it to Your Lordship notice. That's all.
Now, the appeal is against this same judgment. No, that is in respect of that.
Where the issue involved is the same. So based on that.
Earlier judgment based on which this just judgment was passed. Yes, this judgment. Okay.
May it please my lordships. Lordship, only yesterday I saw in the local dailies
Yes.
that they have published against the petitioners notice in the local dailies. Only yesterday I saw it in the local dailies. Now here there is no stay, nothing, and it's only regarding condonation of delay, and IA has been filed. Only an IA, Lordship. Now my humble submission before this honorable court is that I pray before this honorable court that this honorable judicious court, that nothing has been passed in the appeal. What has happened is this honorable court, by order dated 25/2024, directed the state respondent to advertise the post within 6 months. That was the direction given in the earlier writ petition, that is passed on 25/2024, within 6 months. What has happened is within until then, the petitioner, let the respondents be in service. Now that was passed in the earlier judgment order. What has happened is after expiry of 6 months, the respondent government approached this honorable court in IA for extension of 6 months again. Without our consent, 4 months was extended after 6 months expired. 4 months were extended. Now they waited for, they are saying that they are, and their plea before this honorable court is that they are taking steps for advertisement of the post. That was before this honorable court, they submitted, and only for processing for advertisement, this honorable court granted 4 weeks only on the process of advertisement. 4 months, Lordship. Now they waited for that, and after that, it's not the state, but after 4 months expired, now the respondent, private respondents whose service, whose appointment orders were challenged and quashed, now after the expiry, more than expiry of 4 months, now on 27, they have filed. So this is, they have filed IA for condonation. What has happened is, in the meantime, this respondents who have filed the present writ appeal before the Honorable Principal Bench. They approached the Supreme Court. They filed SLP. Now, in the SLP on 2025, the Supreme Court has already rejected their SLP, Lordship. After that, Supreme Court rejected their SLP, dismissed the SLP. Now, after waiting for such a long time, again, after the expiry of 4 months extension time, they have filed the writ appeal. I pray before this Honorable Court, nothing has been done in the writ appeal that they have filed, and only IA for condemnation of the. I have not seen the notice plained, so I cannot say what is the IA about, but I saw it in the newspaper. Now, Lordship will, I pray before this Honorable Judicious Court that this is a landmark judgment for the state of Nagaland. When this constable as well as this UBSI, the present writ appellants, this was dismissed by this Honorable Judicious Court. This is the first time in the history of Nagaland where backdoor appointment was quashed by the court, and the whole state was jubilant about this case. In fact, even in the northeastern state and in all the TVs, in all the social medias, it became so popular. Now, Lordship, they have been in service for 1 month and 2 after the passing of the judgment order. They have been in service till death, and that is 1 year and 2 months by now. And they just want to continue extending that benefit. Lordships will kindly put my Lordship's judicious mind into it, and how it has, for delaying tactics, everything has been done. And I pray before this Honorable Court that only IA notice has been issued. Now, for this hearing, I have even filed for vacation of the status quo order that was passed by this Honorable Court. But this Honorable Court was of the opinion, and in fact, the records are bare before this Honorable Court that the respondent keep on postponing the case. And it's not that we don't have anything to do, and we are not only on this case. And since after that, it has been postponing until there is also IA line for vacation of the interim order. But this Honorable Court was of the opinion that instead of vacation of the status quo order, the matter may be heard. I filed the I just humbly pray before this Honorable Court. Their only contention before this Honorable Court in the appeal is that they were not allowed, their previous counsel subscribed before this Honorable Court that the first writ petition, bunch of writ petition will cover their case because it's of a similar nature. So more than 7 months time was granted to the opposite party to file their affidavit in opposition, but both the state as well as the private counsel, they say that they will be covered by the first bunch of writ petition. Now, after, and my Lord will kindly appreciate that they are just, their prayer before this Honorable Court is to remand back this, remand back the case to the single judge to rehear again after they file their affidavit in opposition. That is the plea before this honorable court, and in other circumstances, they said that their case is quite apart from the constable case. That is what their submission before this honorable court. So, Lordship, that is their humble prayer before this honorable court that they may be given opportunity to file their affidavit. But in this matter, Lordship will kindly consider the fact that when a matter is remanded back for re-hearing, only when the case is dismissed for default of the advocate's non-appearance, inaction, deliberate omission, misdemeanor, etc., with sufficient reason that when there is merit in the case. Merit in the case. This is a backdoor appointment. I am not on anything, and I'm only on whether there was advertisement as per law when they were appointed. That
Go into that merits later.
Lordship.
But right now we have to decide whether we will hear it.
Lordship. Yes.
Right.
Lordship.
And so here, what about 189 to 199? Is it just what transpires is that is a similar issue?
Lordship.
What was that issue? That was related to constable? Or
Constables appointed
and this
through
what?
backdoor.
This is what?
This also UBSI SIs appointed through backdoor.
I'm the appellant.
Huh. Yes. You
Clarify.
I am for the petitioners, now respondents.
She's for the respondent. Now it's like in short, and in a very simple way, I would like to submit lordship. As many as 13 writ petitions were filed before the Honorable Court.
13.
13. Challenging the appointments on the ground that there's a backdoor appointment, all this, whatnot. The matter was, it was altogether 13 cases. Out of 13 cases, one case pertains to sub-inspectors and assistant sub-inspectors of police. That is the present writ appeal which is before your lordships. Out of the 13 cases, 11 cases were heard on 20th August 2024. Exactly after a month, on 20th September 2024, the 10 cases, that is from WPC 189 to 199 of 2022, has been disposed of. So 2 writ petitions are pending. Out of 13, 11 has been disposed of on 20th September 2024. 2 cases are left. Incidentally, these 2 cases, one is sub-inspectors, that is the present writ appeal, and another writ petition is WPC 318, and the present writ where writ appeal has been filed is WPC 138 of 2023. Earlier pages were 2022, 189 to 199 of 2022. The 2 cases which are remaining without hearing on 20th August is WPC 317, that is the present writ appeal, which is pending, and the other is pertaining to constables, that is 318 of 2023. So after pronouncement of the judgment on 20th September 2024, in the 11 cases, 2 cases which was left unheard was heard after 5 days. And by relying on the judgment which was passed in the 11 writ petitions, the 2 writ petitions, one pertains to the sub-inspectors and the other pertains to 164 number of constables. That has been disposed of by relying on that judgment, which was passed on 20th September 2024. Now, the subsequent judgment out of the 2 cases, which was decided on 26 September 2024, this present writ appeal has been filed in one of the cases. During the pendency of this, the constables, the way to approach the apex court has dismissed it in limine. So they may have tried their luck in the principal seat. My learned friend has made submissions that as if it is me who is approaching the Supreme Court or the High Court. No, I'm concerned only with this present. But then, since in the other cases, writ appeal has been filed, and that is the basis of passing order in this present writ appeal. Therefore, the judgment and basing on which it was passed is under challenge before the principal seat. Actually, it should have been challenged here, but I have learned that the permission was granted on the ground that if more than 1,000 constables are dismissed or removed from the service at the stroke of a pen, then there will be law and order problem and there are serious consequences. Maybe the Honorable Court was satisfied with that, and then it is admitted there and it's pending. Now, whether it should be heard today or not, the implications, I leave it to your lordships, but the implications I would like to state in this way. If this writ appeal is heard and disposed of, there will be no implication and no consequences. But the judgment which was passed on 20th September 2024, basing on which this order was passed, if that is interfered with by the appellate court, then automatically there will be implication in this case. Therefore, the best and plausible and reasonable step, what I think it to be correct will be, let that writ appeal be heard first, and up to disposal of that case, this matter may also be heard. That is what. My learned friend has made a submission that I have seen in the paper, and the notice was issued only in the IA. Obviously, when the writ appeal is combined by a condonation application, normally the notice will go on the condonation application, so it will go only in the IA, not in the main writ appeal. Therefore, Lordship, since the main case is sub judice, the similar matter on the basis of which this present order was passed. So let that writ appeal be disposed of first, and thereafter this matter may be heard, so as to avoid any complications and committing any mistake in future.
In that case, we have to wait for long.
Exactly, Lordship.
But then,
Yes. Have you, I think there is IA in this case for vacation.
For vacation of the status quo order.
Status quo order.
Yes, Lordship.
So that.
With or without status quo, the problem here is the respondent government is not willing to take action in this case. And my lordship will kindly appreciate that. This is a backdoor appointment and the learned single judge.
That is true. That is true.
Yes.
But then you see, we have two options as submitted. One is to send this case also along with that.
Can be
appeal
put together.
To heard together.
Lordship,
because if we have to stay, if we have to wait for that, it will be too long.
Yes.
And after disposal also, what will happen,
Exactly.
we do not know.
Lordship.
So instead of that, for once along with that, if this can also be heard together, it would be much better. Or the other way is to wait for the disposal of that, because if the consequences is going to affect this case also, then
one aspect, Lordship.
yes.
One aspect is that, as I have pleaded before this honorable court, that their only prayer before this honorable court in this matter, in this writ appeal is, though it is covered by the previous
Yes.
judgment, their prayer before this honorable court is to revert it back to the learned single judge to let them file affidavit in opposition. If I'm not.
So that also, because these, in any case, this judgment was passed based on that judgment only.
Lordship.
So that is why it is going to affect if that judgment is affected.
Lordships.
So
does
that's
it
there,
fit
yeah.
or-
So you have filed IA also.
Yes.
And then you can make a prayer for IA before the same court, if it is sent along with that case.
No, Lordship, this
That
honorable
appeal.
court has the power, inherent power, as well as power and
That is
authority to vacate the interim order. Interim order is only praying before this honorable court that they, basing upon the status quo order, has been prolonging and delaying this case. That's why.
By the way, what is the status of this constable, whether they have been removed or?
Nothing. They are still in service. That's
Still in
the-
service.
Yes.
Any status, any order passed? Extension.
Extensions were given for 4 months.
So in this case.
In so far as
Not
this
really,
case
not
is
Based on the status quo. order.
Yes, Lordship. And constables, after expiry of 4 months, they have now filed writ appeal before the principal bench, Lordship.
But not in
Now-
this case.
Not in this case. Now, what has happened is, even before when this constable approached the Honorable Supreme Court, this matter came up before this Honorable Court, and this Honorable Court, before this Honorable Court, they have submitted before this Honorable Court that does not cover them, because they are before this Honorable Court for remanding back the thing. Now, to my
Remanding back to the single bench.
yeah, that is when there is a merit on the merit of the case, Lordship. Merit in the case. This is about backdoor appointment, Lordship.
That will
And
last
it
only
cannot.
when the writ appeal is-
Yes. Whether writ appeal or with or without writ appeal, Lordship. This is a backdoor appointment case, and Lordship, if this Honorable Court take up this matter in the same, this has been pending since 2024. This writ appeal. So how the recent writ appeal that was filed recently, this has been pending before this Honorable Court. So how that, since that writ appeal does not affect them, they have filed before this Honorable Court this writ appeal. So to my humble submission before this Honorable Court, let this Honorable Court take up the matter, whether lose or win, on my part, to be fair. Lose or win, this Honorable Court take up the matter because it's pending for more than a year, and that was just filed recently on 27th, it came up. And let only condemnation, no stay.
What we are suggesting, we can wait till the condemnation is over. If the delay is not moving, then the appeal is no longer waiting, but waiting.
Just because they have
Can you
filed
come to
that
page
appeal,
392 of the appeal memo?
just my humble one submission,
392.
whether
Just
this Honorable Court.
one at a time.
Appeal memo. 392,
What is
paragraph
that?
10. My learned friend T.B. Jamir has referred to paragraph 5 so as to show the similarity and whether it will be appropriate to take up or not. Again, more clear in paragraph 10. Page 392, has your lordship got it? Ms. Zimomi, learned counsel appearing for the petitioners, has submitted that the fact situation obtaining in the page of writ petitions, that is 189 of 2022 to WPC number 199 of 2022, is similar to the fact situation obtaining in the present writ petition, and as such, this writ petition shall also be disposed of with the same observation and direction. So we can assume a situation that it is same. And that issue is pending before the principal seat. Whether it will be allowed or not, that is another aspect, but it is pending. So in order to avoid any complications in future, it is better that we should wait for the outcome of that appeal.
At least the
That-
condonation.
Yes,
Let's see what happens to the condonation.
And
If it is not condoned, no appeal.
yes,
So then
so
we can hear
we
it.
can wait.
So we will.
Yes, it is fixed in the month of August.
Till the IA is
Just
disposed
matter
of.
of 1 month.
in that matter, Lordship,
Hmm.
I have one submission. The IA that I have filed for vacation of the status quo order,
Hmm.
that may be vacated by this Honorable Court. And in an event, if this Honorable Court's opinion that this matter be clubbed up together with the bunch of the writ appeal that was filed in the principal seat. My lord, I humbly pray that I was informed that in the principal bench, the appeal was allowed to be filed on the basis that after the motion stage, the matter will be transferred to the Kohima bench.
That's why.
So,
It's
Lordship,
better to wait.
Lordship, that is my humble submission before this honorable court, that if it is clubbed up together,
Now.
Delay may not be condoned. In that eventuality, then entirely the bill will go and then this matter can be taken up.
So we can wait till
Okay,
then.
so,
Yes.
IA won't,
IA
IA
for
probably will
condemnation.
not take much time for disposal of the IA, delay condemnation petition. So we can wait till the disposal of the delay condemnation petition. And thereafter we'll decide. Thereafter,
my IA for status quo vacation. What is the use?
it has been since it has been listed for hearing. we'll take-
That is different from this status quo order that, because basing upon this status quo, we don't know how long it will take, but basing upon this, the records are very clear before this honorable board, how much they have been delaying this case, Lordship.
No.
And we have no option. And Lordship, the leniency of this honorable court, if it is taken for granted, if it is taken advantage of by me or any counsel, Lordship, that is not justice. This is unfair.
Previous order. In fact, I submitted and I argued. After hearing to some extent, the matter could not be heard. It's not that I have been playing telling tactic, as my learned friend,
It is
Lordship
in the
may
open court.
see from the record.
It is not in the open court.
And the way that my learned friend is submitting that even the writ appeal which has been filed in the principal seat, as if I have done that. No, I'm not there.
Lordship,
Anyway, the order was in your favor, you need not worry, only the status quo is there.
of
Right.
course.
Then let the entire matter be heard together after the I is.
After the IA.
After hearing the I. Yes.
Okay. Pardon, Mr.
Lordship,
Sorry.
let the direction be on the day of, right after hearing the IA. And also, Lordship, the matter be listed here. This is my house.
This will be listed
Lordship.
after the I.
After IA, after the disposal of IA, so matter will be listed here only. So let us, and thereafter we'll see what.
Very difficult, Lordship.
It may be
Very
listed
difficult.
We'll fix it after 1 month. Please.
We do not know. How long ago?
Otherwise, I was thinking to my small knowledge, Lordship. I have to say, I have to submit like that. This honorable court can make a settled precedent in this case. And whatever in this writ petition that was filed in 2024, if this honorable court judiciously pass a judgment order, the other that was filed before the honorable principal bench will follow, will cover. That is also one aspect.
There should not be any conflict. Let us wait.
Mr. City Jamil, National Council, assisted by Mr.
Aliba was a come.
Aliba, Land Council for the appellants staff. Also had Mr. Z. Moment. No, sorry, who is the respondent number 1? Additional AG, for the respondent number 1. What for what? Okay, one, okay. Additional agent for respondent number 1, Mr. Jamira. For respondent 2. 2 to 5. And Ms. Jamomi for?
6 to 20,
Okay. 6 to 20. Start.
assisted by Toshio
Okay. Okay. Jamomi, assisted by Toshio Longkumar and counsel for the respondent number 6 to 20. Start. Mr. TV Jami, line counsel for the respondent number, line counsel for the respondent number 2 to 5. Inform this court that the appeal, writ appeal, okay, please.
How much?
Right, 3 writ appeals filed by the.
Yes.
3 writ appeals. Okay, number. Filed by the aggrieved in connection, okay.
Against the judgment and order dated.
Against the judgment and order.
2024.
Judgment and order dated.
2024.
2024.
Passed in WPC number 189.
In WPC number
2022 to
To
199 stroke
2024.
2022.
Have you written? Okay. Is pending before the principal seat. Okay. Along with the.
IA number
Along with the condonation petition, the IA number
2106
2106
obliques 2025.
2025. Stop. And some is that the matter may be listed after the disposal of the said writ appeal. Stop. Okay. Writ appeal. Stop. In view of the above, let this matter be listed immediately after the disposal of the condonation, disposal of the IA number. Right, IA. Huh? There is 3 IA. Okay. I mean, immediately after the disposal of the 3 IA for condonation of delay in filing the writ appeal.
Lordship, can it be given a fixed date after?
Immediately after, you make a mention also. Immediately after, I said immediately after the disposal of the writ IA.
It may go on.
It depends upon the contingency.
Can we mention that?
Immediately after, if you get an information that the IA has been disposed of, you make a mention and obtain a copy of the IA disposed of. Okay. So we'll take up the matter. Okay. List this matter accordingly. Okay.
Obliged.
All my life. When I'm like this, on my right. That is the one which is not working. Then the sound is very low.
Wait. What? Break. Hello, check. Proceed.
Next we go, direct pilot.
For hearing item number 13.
Lordship, here in this case, my colleague is seeking for adjournment.
This is item
13.
13.
Okay.
Yes, but he has been enjoying the interim since 2022, and he has been postponing the matter over and over again. So, my lordship, I pray that adjournment can be given subject to the interim order packet. Lordship.
My lords,
You have a very strong objection.
my lords, I have a submission that
Yes.
after
What is
the-
this case about otherwise?
Lordship, it's about the appointment of the assistant headmaster as well as the junior education officer. That is at page 40 of the page 40. This is the advertisement, 56 posts. We have advertised 56 posts to be filled up through limited departmental examination. And this court on the 30 of August 2022 has taken this advertisement for which the school is suffering, Your Lordship, because 56 posts of assistant headmaster is lying vacant.
By which order is was stayed?
38 2022.
22.
Yes.
This is a repetition.
And it's more than 3 years now.
This is a repetition.
Yes, they are challenging the virus of the rules.
After that, any new advertisement?
No, because of this stay, it is kept on suspension.
No.
For which reason we could not go ahead with the.
Virus is challenged. He can.
Even if
His
you go
lordship.
into the merits, also the petitioner, they do not have the merit of the case, for which reason they are keep on adjourning the matter. So my lordship taking into consideration the difficulty facing by the school because of the non-availability of the assistant headmaster. My prayer is that the interim order may be vacated.
Now this advertisement is for recruitment
For assistant headmaster,
Assistant
junior
headmaster.
education officer through limited department.
But through limited department
Yes,
only.
Yes, through limited department. It is an in-service exam.
Yes.
Yes. So they are challenging that virus, whereas they have no merit of the case. They got the interim order in the favor. Now they are taking the advantage of the interim order. They have been postponing, adjourning the matter. It's been more than 3 years, my lord.
So all the affidavit have filed.
the lordships. I have a submission that after the matter was fixed for hearing, according to me, this is the first adjournment.
No,
and
no.
I'm
I can read out the date.
How can that be? 22, it was adjourned.
Yes, since 2023, they have been adjourning.
And moreover, Your Lordships, I'm not counsel in this case, and without hearing the leading counsel, if vacation is interim is vacated, then it may not be here, my lord. It's just the final hearing, so
So then what we'll do is we'll fix it next week, next Wednesday.
He says his senior will be out of station again next week.
No, no.
my
That
lord,
cannot be.
may
You come prepared. You
last
come prepared
opportunity
next
may be
week. You
given
come
and fix
prepared.
the matter on 30.
So your lordship, the
Lordship.
schools are suffering because of it. So in that
Because
case,
this is for final hearing, then 30.
You do it, take the opportunity, do it. You prepare it, you have enough time.
Yes.
Okay.
I'm not following this case, Your Lordships.
There are 3 councils here.
Yes.
Yes.
So let one of them do it.
None of them are here, Your Lordships.
Just a minute. Next is 24. Okay, his senior.
Fix on 30
Yeah,
as
sorry,
the final,
23rd.
as the final chance.
You want this matter to be fixed on 30?
Yes, my lord.
30.
30.
We'll do it.
no, even on that date also, they will seek adjournment. I have
No,
the
no,
report.
no, no. We'll make it sure that on that day,
No further adjournment.
no further adjournment.
If I pray that there is an urgency for which matter I've been repeatedly seeking this court. So if that is the case, the interim order should be vacated. Because if we go through the merits of the case also, the petitioner, they do not have a case.
But then in absence of any application for vacation of interim or.
But this, of course, that is understandable, Your Lordship, but even this court also has the jurisdiction, even
Yeah,
to
you
interfere into
you
the
make
matter.
one small application for vacation of the interim order. We'll incorporate it on the next date. If they remain absent,
Lordship.
we'll take up the vacation.
Lordship.
Okay.
Hmm.
We'll fix it on 30.
Okay.
In the meantime, you make an application.
Or Lordship, next week we can fix it. Because there is an urgency in the matter. Even if his senior cannot take up, also the other council can direct up because the matter cannot be kept online
On
in this
30,
manner.
on 38. Okay.
Last chance on 30th.
Last chance. Okay. Mr.
P.
Mr.
P. Soto.
So the Lanark Council submits that his senior is out of station and therefore pray for adjournment of the matter. Miss. It's okay. Lanark Additional IG. Shown urgency in the matter and prays for taking up the matter for hearing. He further submits that if the matter is to be adjourned, the interim order should be vacated. Okay, in view of the above, in view of the above and urgency shown by Ms. Sokri, let this matter be fixed on 30th.
30 of July.
30 July. On which date the matter shall be taken up for hearing and no further adjournment. So it is made clear that if the matter is not taken up for hearing on that day, the interim will you file application or just?
If necessary, I'll file, but that may not be recorded.
Okay.
If necessary, I'll file.
Okay, then that will do.
Much of it.
For hearing, item number 18.
May I please, Lordship, Lordship, this is the last day for this bench. We don't know when this bench will be constituted next, Your Lordship. But here, Your Lordship, this, by the judgment which is under challenge, Your Lordship, the learned single judge has dismissed the writ petition on ground of delay, Your Lordship. So there is no legal issue or question of law involved here. The Lordship, what needs to see is, based on the facts as per the record, whether there was any delay on the part of the petitioner or appellant in approaching this honorable court, Your Lordship. So if Your Lordship is, as I've said, this was the last day, but I will.
How long will you take?
I'll try to conclude within 1 hour. Next week. Next week also.
Matters of industry. Next week. Next week again. No? I can write it.
Okay.
No, write it.
Okay. So,
Can you finish it today? I mean,
Yeah, maybe within an hour.
can you go ahead with the hearing?
So even me, I won't take much time.
Okay,
Yes, I'll
okay,
just
we'll
do
go
that
ahead
in
then.
my-
Okay.
I'll just take Your Lordship to the level portion, Your Lordship. Now, before I take Your Lordship to the impugned judgment, Lordship. Now, the subject matter here, the subject matter relates to promotion from the post of Assistant Sub-Inspector, Women Police, to the post of Sub-Inspector, Women Police. And seniority, interest is seniority. Now, at the time when this writ petition was filed, the appellant, the petitioner, she was serving as ASI, Assistant Sub-Inspector, Women Police, but subsequently, during the pendency of the writ petition, she was promoted to the post of Sub-Inspector. And Sub-Inspector is unarmed branch. They are armed branch, unarmed branch. Unarmed branch, Sub-Inspector, Your Worship. Now, that is the subject matter. Now, may I take Your Lordship to the prayer, the writ petition, Your Lordship, because altogether 14 prayers were there in the writ petition. Altogether, Your Lordship. Yes. Now, except for prayer number 10, 13, and 14, the appellant is not aggrieved by the finding of the learned single judge. So by preferring this appeal, the appellant is pressing only prayer number 10, 13, and 14 to the writ petition on the ground that there was no delay or laches in seeking the relief. Now, may I take Your Lordship to the writ petition, which is page 46. This is writ petition. Your Lordship, there were 3 writ petitions, and it's a common judgment. So this is writ petition. Page 46, Lordship has got it. This is writ petition for 85K 2016, where the appellant was the petitioner. Now, the prayer is page 80. Prayer portion is like reading pleadings, so many prayers. Prayer starts from page 80. Lordship has got it. Prayer 10 starts from 83. Prayer number 10. I am pressing only this.
other prayers you are not aggrieved of.
Other prayer, I'm not aggrieved. I accept. Prayer number 10, may I read out, Lordship? The impugn office order number such and such dated 4/10/2013 passed by the Director General of Police Nagaland Kohima. Central promotion test was conducted from 25/26/9/2013 and on the recommendation of the board, 50 ASI were declared pass and kept in the fit list for promotion to UPSI. And particularly inclusion of petitioner's name. Petitioner is aggrieved because her name is included in this fit list of 20, this is, I'll say fit list of 2013. Because this is the fit list and fit list, Your Lordship, for promotion to the post of SI, Your Lordship. A central CPT is conducted, central promotion test. And based on that, the list who are selected in the CPT, Your Lordship, the promotion is given to the next higher grade, to sub-inspector. And petitioner is aggrieved by inclusion of her name in this fit list of 2013, Your Lordship. Now, why I am aggrieved by this?
Why was she agree? Why was he agree?
Because her name was included here. Because she has completed her fit, she's included, her name is already there in earlier fit list. 2008, Your Lordship. Now, because since promotion is given as per the fit list 2013, now if she and her name is placed below.
Okay.
Below.
Only because her name was placed below, that is the case.
So if promotion is given as per the fit list, that will be in violation of the rules, because as per the rules, it should be as per the fit list. Once the fit list, the earlier supposing earlier fit list that is exhausted, then from new fit list, promotion will be given. And her name is already included in 2008 fit list.
In the earlier fit list.
In the earlier fit list.
Okay, therefore she is aggrieved that. Okay.
Yes, earlier fit list, Lordship may kindly come to page 115.
How many petitions?
115. Type copy is at page 115A. 115, Your Lordship has got it?
Yes.
Yes, serial number 5.
She's
Now,
still alone.
may I read? Or this is order dated 31st March 2008. In persons of police headquarters, order of even number dated such and such, central promotion test of ASI woman/police was conducted by the board on this date. On the recommendation of the board, the following ASI woman police are hereby declared pass, are kept in fit list for promotion to the rank of UPSI. UPSI means unarmed branch sub-inspector, Your Lordship. Woman police. And the name of the appellant petitioner is at serial number 5, ASI Sashila Lunkumar, Your Lordship. So being aggrieved, Your Lordship, the petitioner has submitted a representation. Representation is at page 187.
Agreed by which one?
Agreed by inclusion of her name in the fit list 2013. Because her name is already there in 2008.
Representation at?
183. Type copy given. Now, representation, Your Lordship, I will take only relevant paragraph. It was 2-4 against encadrement and 11 against the fit list, para 9. Page 185. Para 9, Your Lordship. It relates to the meeting minus senior held in connection with encadrement of women police. So this prayer, which I made in the petition, I am not, because it is the prerogative of the employee whether to encadre or not. But this representation, para 9, relates to encadrement, and para 11 May I read out? Para 11, that by office order number such and such, the CPT conducted from such and 50 ASIs were declared pass and kept in fit list for promotion to higher rank of UBSI in this comparative position is given below. Now, next, my name 187, my name appears as serial number 44.
Exempted means?
Exempt, I don't know why that, because I have not undergone the CPT because I have already undergone it. I have done in 2008. It is stated here that I have not been sent for CPT 2013. Because she has not been sent for CPO, she has already completed in 2008. Since I have cleared CPT in 2008, not only that, my juniors are placed much above me in CPT 2013, which is totally illegal. Now, this representation was rejected, but by next page 188. The type copy, page 189, type copy. Now, I am directed to refer your letter number such and such, respectively, regarding representation submitted by ASI Sashinaro and her friend, Sashila, Crime Branch, to convey that the decision taken by police headquarters in regard to encadrement of posts and maintenance of common senior list for male and female UBSI for the purpose of promotion cannot be undone. Review now. I am not pressing that prayer, which I have made in writ petition against encadrement. This is a prerogative. You are therefore requested to inform the ASI of your respective establishment that if the officers are not satisfied, they are given the liberty to seek justice in the court of law itself. Now, Your Worship, my representation was twofold. One was against encadrement, which I am not now pressing. The other was regarding inclusion of my name in the fit list of 2013. Now, the authority totally silent on that, only on encadrement, Your Worship. Now, the condition of service of the ASI, Your Worship, is governed by the rule, Nagaland Police Manual. And this manual, Your Worship, this manual is not, is framed under 309. So in my respectful submission, Your Worship, these are a statutory force. And this was published, notified on 8 March 2010, Your Worship. In the Gazette, I've given the copy, Your Worship, 2010. And in support of my submission that though it is a manual, it has statutory force, Your Worship, may I place you on case law. This by 3-judge bench, Your Worship, para 26. Yes, para 26, just for Your Worship's satisfaction. Para 26, third line. Lordship has got it, para 26. Lordship has got it. Third line. We also hold that the IREM has statutory force and has been issued in exercise of power vested under the proviso to Article 309 of the Constitution. Here, this is also manual, railway manual. Here also it is manual, not rules, Nagaland Police Manual. It has got statutory force, Your Worship. Here the issue was whether Indian Railway Establishment Manual has statutory force. But this Indian Railway establishment manual is also notified under 309. So it has statutory force. Similar, like though we say it is police manual, it is not a manual, it is a rule. It has statutory force. On the relevant provision, Your Lordship, Section Rule 34. I may be allowed to read. Lordship has got it, Rule 34. Central promotion test for promotion. The Office of the Inspector General and Director General of Police will conduct the central promotion test for promotion to the rank of inspector such and such. Now B, C, the concept of merit cum seniority to be applied in all the promotion tests conducted by the department to the extent that an officer has to qualify the basic minimum test CPT required for the promotion to the next higher rank. No junior batch will supersede the senior batch. This is relevant, Your Lordship, basing on the result of central promotion test, unless the senior fails to appear or fails to pass the 3 such consecutive tests, or before the senior passes the test, vacancy arises and the junior is in the fit list and promotion effective already. D, I'm also relying on this. I'm relying on this, Your Lordship. The Office of the Inspector General and Director General of Police will conduct the CPT every year or well ahead of the exhaustion of those in the fit list. The subordinate units shall also conduct the promotion test for all other subordinate rank in a similar manner. My submission, Your Lordship, is that only after exhausting the 2008 CPT list, where my name is included, then only promotion can be considered from 2013 CPT list. Now, when I have already qualified in CPT, my name is included in 2008 CPT, Your Lordship, for promotion to the rank of sub-inspector, Your Lordship. My name has been included in CPT fit list of 2013, and I have been placed before the juniors. My junior, Lordship. So juniors has been made to supersede, and promotion has been given. In subsequently, I will invite the person was submission. I will say promotion has been given from 2013 list by superseding me, which is against the rule. Your Lordship.
The word use is or.
Lordship.
The office D, you are placing the D, na, clause D.
Yes.
The Office of Inspector General and Director General will conduct the CPT every year.
Every year.
Or well ahead of the exhaustion of those individuals.
Yes. That means only
every year or.
Only, but it says that once the list has to be exhausted and then the next, Your Lordship. Now. So in my respectful submission, the fit list of 2013 is prepared in total violation of Rule 34 of the Nagaland Police Manual, Your Lordship. Now, Your Lordship, my representation which I have submitted on 16/11/2023. 16/11/2023.
Page.
My representation, which Lordship submitted a representation, I have taken Your Lordship through page 183. This date is relevant, Your Lordship. 183, this is the type page. In the type page, date is not. I have submitted my representation, page 83, 183.
2016.
On 26/10/2013. Representation was rejected on 16/11. This is against the fit list. Then, Your Lordship, I have approached this honorable court in January 2014, 2 months thereafter, immediately after rejection of my representation, and which is reflected in the judgment also, Your Worship. May I take Your Lordship to page 298? Your Lordship. The last page, 298, Your Lordship has got it. 10 lines from the bottom. 9 line. On 16/11/2013, Lordship has got it. The petitioner was duly informed that the representation cannot be accepted as the decision taken by the police headquarters as regards the encounter of post and maintenance of government senior list for male and female UBSS agencies and for the purpose of promotion cannot be undone and reviewed. Thereafter, on January 2014, that is 2 months after that, the petitioner for the first time approached this court by filing 3 separate petitions, being 9, 10, and 11, Your Worship. Lordship has got it? No. Now, 2 months, Your Lordship, there was a difference after rejection of my representation. So my case is,
Can you withdraw?
because during the pendency, Your Lordship, the opposite party number 7 from list 22 were promoted, so I withdrew and I impugned that promotion order. Lordship. Now the record speaks for itself in my respectful submission that there was no delay on the part of the petitioner in challenging the fit list. Fit list of 2013, Your Lordship. That is prayer number 10, Your Lordship. Then there was no delay. Now coming to prayer number 13 and 14. 14 is consequential. Prayer number 13, page 85. So my first submission, Your Lordship, is that so far as prayer number 10 is concerned, there was no delay. Now coming to prayer number 13.
2 months.
2 months. After 2 months, immediately after rejection of the representation. Now prayer number 13, Your Lordship. Impugn office number, this is 2 questions set aside. Impugn office order number dated 30/3/2015, passed by the Director General of Police Nagaland, promoting from CPT fit list as many as 10 ASIs to the rank of UPSI, namely, Your Lordship, I'm coming to this, the 10 were appointed, but I am seeking relief since I'm not pressing other prayer, I'm seeking relief only against number 7, who is implemented as OP7. Should not be questions set aside. And prayer number 14, Your Lordship, to promote the petitioner to the rank of UBSI with retrospective effect as per the CPT fit list dated 2008. That is, as per 2008, I should be. This is consequential, Your Lordship. Now, this promotion order, prayer number 13.
You have no grievance against these other persons?
No.
Only 7?
Yes.
She was junior?
They were junior, and the others are, they are male, because compensation. They are male SI. So I have no. I will come to that. I will satisfy Your Lordship on that. Now, may I take Your Lordship to the promotion order, which is at page 171, which I've challenged as prayer number 13. 171, but type copy 171, Your Lordship. This is the promotion order. Here, Your Lordship can see only the date. I have typed copy, but here the date is 4th October 2013. This is the promotion order. Relevant part, by page number 174. Type copy. Oh, sorry, Your Worship.
This
I'm so sorry, Your Worship. 192 is the promotion order. I'm so sorry. This is the type copy. 191 original copy is also eligible. Lordship has got it, 191 promotion order. This is on 30th March 2015. And serial number 7, she's opposite party numbers. I am seeking relief only against her, Your Lordship. Now, Your Lordship. When the field list 2013 was under challenge in writ petition 8, 9, and 10, Your Lordship, during the pendency of the writ petition, Your Lordship, this promotion order was issued based on the field list of 2013, Your Lordship. Of course, there was no stay order, but that was under challenge. So in the teeth of challenge being made to the field list of 2013, the promotion order was issued, Your Lordship. Therefore, petitioner withdrew the writ petition with liberty, Your Lordship, to file the fresh writ petition challenging the promotion order. The withdrawal order of the writ petition is at page 194. So with liberty to file, liberty has been given, Your Lordship. So far as prayer number 13 is concerned, Your Lordship, when opposite party number 7 was promoted, when the field list was under challenge, Your Lordship. Now, whether there was any delay on my part in challenging the promotion. So in my respectful submission, Your Lordship, there was no delay on my part in challenging the promotion of the opposite numbers 7, Your Lordship. Now, as I am seeking relief only against OP7, opposite party number 7, Your Lordship, may I also clarify on the parties in the writ petition, Your Lordship. Writ petition starts from page 46. Altogether, 68 respondents were there. And parties in the writ petition starts from page 55.
Why so many respondents? They are all promoted.
Sorry?
Why so many respondents, private respondents?
68 respondents.
Hmm.
68. Because here they have included even the mayor, SI who are totally different, Your Lordship. And after the encouragement, those issues, and then those who are directly recruited and promotees, so they were also included. So I have no grievance against their promotion. So from 55, the party starts. Respondent 1 to 6 are state respondents. Seven to 66 or 7 to 68 are respondents, the private respondents. And opposite party number 7 in this appeal is arrayed as respondent number 63. Lordship, you say 63 is Henry Legend. And just to clarify, your 1 to 6, your Lordship, there's the respondent. 7 to 17, respondent number 7 to 17, they are direct recruit UBSI. 7 to 17. And petitioner is not, applicant is not seeking any relief against them.
Direct recruits.
Directly. And except for respondent number 63, who is implemented as OP7 in this, your Lordship, others are all male sub-inspector. So they're general, they're different. Yes.
Not recorded.
Still no record, but then I met the party. And 67 and 68, your Lordship, they have been made pro forma respondent, which is at page 64. Because they are the appellant petitioner is direct. Appellant petitioner and OP7, they are direct recruit ASI. But 66 and 67, they are pro forma respondent because they are promotees. And we are not seeking any relief against them. So only respondent number 63 has been implemented in this appeal as OP7. 1 to 6 are state respondent, Lordship, because others I'm not seeking any relief against them. Now, both before the read court and even this appeal, though the notice has been served, respondent opposite party number 7 has not contested.
In the writ proceedings or what? Not
Even
yet.
in the writ, even
Proceedings also they did not, she did not.
Now, may I take your Lordship to order dated 23/2024? By this order, 23/2024, notice upon OP7 has been treated.
In appellate jurisdiction?
Yes, in this appeal. Order dated
23.
23/20.
Two zero 23.
23/2024.
Yes.
20.
Order passed by this court.
Yes.
There is no such order.
Notice is deemed to have been completed upon open. I've been permitted to take justice service. I've also filed compliance affidavit, Your Worship, and then
It's not true.
Is it 20?
20. 3/2024 as per my noting.
2024.
2024 as per my noting the file, because I've been permitted to take justice steps and then to file an affidavit.
In fact, there is an office note where it is said that the service is complete.
That photo is missing with the years.
This is 21/8/24. Notice upon respond number 7 is declared to be complete.
Complete. Yeah. Otherwise, even as per the case status, even
Acha.
then the date is there 20.
Otherwise, the consignment note was tracked and then it was found out that it was delivered.
And we have also filed an affidavit. We have taken dusty steps, Your Worship.
Oh, acha.
Dusty steps. And then I was asked to file affidavit. So I have also filed, I have filed affidavit also, Your Worship. But even before the report, he did not appear. He did not contest. She did not contest, Your Worship. And I think you'll print out now. Okay. Now,
Can proceed.
now may I take your lordship to the judgment? It starts from page 295, 249 is the judgment. Two four nine. This is writ petition 84. Lordship has got 84. And my petition is at page 258. 258. Lordship has got it. And the third one, that is writ petition 86. It's 264. It's by a common judgment, the three writ petition are disposed of. Now, I'll take your lordship to the relevant page towards the end, page 295, para 46, 252, 6 paragraph.
$295.
295, para 46. Let me read from para 46.
Yes.
May I read out? Thereafter, by an order dated 24/10/2008, the person as serial number 4 of the final seniority list of ASI dated 28/9/2007, and who was at serial number 1 of the order dated 31/3/2008. This is the fit list, Your Lordship. The first fit list, 2008, was promoted to the rank of SI, Women Police. The said promotion of the ASI was against the existing vacancy caused by the promotion of one UBSI Women Police to Inspector Women Police by notification dated such and such. Subsequently, thereto on 1/4/2008, the person as serial number 5 of the final seniority list dated this, and who was as serial number 2 of the notification dated 31/3/2008 was promoted to the rank of the UBSI. The promotion was against the existing vacancy caused due to retirement of UBSI on this. It was mentioned that in the said additional affidavit that subsequent to the promotion of person as serial number 5 of the final seniority list dated such and such, no vacancy occurred in the post of UBSI Women Police till merger of the male and female UBSI. It was mentioned that prior to the issuance of the notification dated 76/2011, there were only 4 posts of unarmed branch inspector, and promotion of these 4 posts could be made only against promotion and or retirement of the 4 incumbent from amongst the senior UBSI petition and not otherwise. It has been mentioned that on 24/3/2017, the petitioner herein were promoted to the rank of UBSI. This is during the pendency, Your Worship. 47. At this stage, it is also relevant to take note of that there is no right to promotion. A person only has a fundamental right to be considered for promotion. Even this court looks into the order dated 31/3/2008. This is the fit list. It will be seen that the petitioner, along with others, have passed the common promotion test and was kept in the fit list in the rank of UBSI. but the said promotion was subject to vacancy having arisen as well as good SCA in the preceding 5 years. Therefore, the question of granting relief to promote the petitioner to the rank of UPSRD petition with retrospective effect as per the CPT fit list dated 31/3/2008 cannot be granted unless and until vacancy arises. Means with retrospect, but then it could have been considered. Even if it's not with, I am saying that I should be promoted with retrospective effect. 48. The next question therefore arises as to whether the petitioner could have been granted all benefit if vacancy arises in the rank of UPSI Women Police prior to the merger. The law in this regard is specified from the various judgment of the Supreme Court that even if a direction is given for national promotion from a deemed date, the promotee is not entitled to heirs. I'm not claiming arrears. Whatever, at least whatever I deserve. Deemed date to the date of posting in promotional post as they had not worked out during the period in the promotional post. Understood. 49. Further, before proceeding on deciding the question of relief that can be granted, it will also be relevant to take note of the question of delay and legacies. The appointment of respondent number 7 to 17 as direct recruit was made on such and such. As I said, Your Lordship, I am not contesting. I am accepting. The said appointment, though contrary to the memorandum dated 6/9/1996, it was contrary to the memorandum, but then there was delay of Government of Nagaland Home Department and more particularly clause 4 therein. But the said appointment were sought to be challenged firstly in the year 2014 and thereafter by way of the present petition. In the opinion of the court, the said challenge on the face of it suffers from delay and ledgers. It is also evident herein to mention that it is the tried law that where appointments are made from one source but are made after following the procedure prescribed by the rules for appointment, the appointee should not be pushed down below the appointee from other source inducted in service at later stage. 50. The next aspect of the matter would be as regards the challenge to the minutes dated 2/7/2011. 2/7/2011, Your Lordship, this is regarding encadrement, which are not pressing, which are. And 5/7/2011, this is encadrement. 5/7/2011 is common seniority list, male and female, male and women police. I'm not pressing, I've accepted. On the basis of which the seniority list of male and female personnel of Nagaland Police were merged, and consequently on 15/7/2011 and 2012/2011, these are 15/7/2011 this is tentative seniority list, and 2012/2011 this all tentative seniority list, and final seniority lists were published. The record shows that on 14/10/2012, representation were submitted by the petitioner. The respondent authorities did not consider the said representation and the petitioner set over the matter. Subsequent thereto, the respondent took various steps for appointment as well as also issued an order dated 4/10/2013 whereby the petitioners were put in the fit list at serial number 43, 44, and 45. I was placed in 44. Other writ petitioner in the 84 was in serial number 43 and 86 was in 45.
Three petitioners.
3 writ petitions. But that
3 writ petitioners.
yeah, 3 writ petitioner, 3 separate writ petition. Well, only I'm pressing. I am filing that. The petitioner submitted representation again on 26/10/2013, which I read out, Your Worship. On 16/11/2013, the petitioner were duly informed that the representation cannot be accepted. So this part I have read out, Your Worship. Therefore, on January 2014, third line, the petitioner for the first time approached this court by filing 3 separate writ petitions, that is writ petition 9K, 10K, and 11K. While the said writ petition were pending, there were further promotion made to the rank of UPSF, for which the petitioner withdrew the said writ petition on 10/2/2016, and after 3 months filed the present writ petition on 31/5/2016.
The other two petitioners have not approached.
They have not approached the appeal. They have filed this writ petition, but not before this court. 51. The petitioner have not assigned any reason as to why there was a delay of almost 3 years in challenging the minutes dated, which I am not pressing, those minutes. Meeting dated 2/7/2011, the memorandum dated 5/7/2011, and the impugned seniority list dated 15/7/2011. In view of such delay, rights have accrued upon others while the petitioners were seeking either. It will also be seen that it was after more than 1 year the petitioner filed the first representation, and thereafter the second representation was filed on 26/10/2013. The impugned minutes of the meeting dated 22/7/2011 and memorandum dated 5/7/2011 and subsequent memorandum dated 15/7/2011 were known to the petitioner. And there was nothing which prevented the petitioner from approaching this court. An interference with the action or response at this stage would unsettle settled matter and which would lead to several complications. Consequently, this court therefore holds that on account of delay and ledges, so the petition was dismissed, Your Worship. So far as the other prayers are concerned, Your Worship, altogether 14 prayers were the read petition, under whatever observation, finding, elaborate, but alert a single case, I accept. But in regards to prayer number 10, 13, and 14, Your Worship,
Promotion was given in 2011, right?
2013, during pendency of
2013.
2013, during pendency of the read petition, first read petition. I'll give you.
No, here the delay and latches were considered from.
Promotion order of opposite party number 7. This is 33/2015, page 192.
But then here delay and latches were considered from the meeting.
From the meeting.
Where is that minutes of the meeting? 2011.
The minutes of the meeting, that is encadrement 147. 147. This is encadrement of male and woman police. So which I have challenged, but that is within the prerogative of the employee.
Now you are not.
Yes, whether to encadre, whether to have a common synergy list. So I am not pressing that. 147.
There was one, these meetings.
Yes.
Were not related to fitness.
No.
Just change his prayers. Just change his prayers. Right. Sickness, he has changed his place. Maybe it can be not in a bad stage. I think those prayers will do it.
Yeah, so.
Learned signatures did not consider those fitness things.
No.
It was not pressed also at the time.
It was there. It was. May I take your lordship just for further clarify your lordship? May I take your lordship to page 17, because here only the facts needs to be understood, your lordship. No, so I've given the brief fact with the appellant vis-a-vis OP7. Page 17. Para 2. May I read out? By office letter number such and such, I have given the page number also. The Home Department, Government of Nagaland. Page 17, 17.
Yes.
17. Para 2. Bottom. Para 2. Sapara A.
Okay.
By office letter number, this is this. The Home Department, Government of Nagaland conveyed to the Director General of Police, DGP, for sanction of creation of 264 posts, including 16 posts of Assistant Sub-Inspector Woman under the Inspector General of Police in Nagaland. B. Person thereto by office order number this, DGP Nagaland Kohima, on recommendation of Selection Board, directly recruited the appellant along with 8 others as Sub-Inspector female in the following order. Now here in bold I've given, appellant is at page serial number 4, OP is at 7, is at serial number 8, your lordship. As per the terms and conditions stipulated in the said appointment, the seniority of the above mentioned directors shall be in the order arranged above, which is as per the recommendation of the select, even as per the selection. I am as per the merit list. In the said appointment order, the name of the appellant and the opposite party 7 are as serial number 4 and 8 respectively. Subsequently, your lordship want to see the annexure? It is, and I have the annex. Subsequently, the DGP Nagaland by office OM dated such and such published the final release of ASI. And in terms of the appointment order, the appellant at opposite party number 7 was placed at serial number 8 and 16 respectively. D. That by order dated such and such, the appellant along with 9 other ASO were sent for CPT for promotion to the rank of UPSI. On being qualified, the DGP Nagaland, on the recommendation of selection board, by order dated such and such, promoted 3 senior most ASI to the rank of UPSI. The appellant along with 6 others were kept in the fit list for promotion to the rank of UPSI. The name of the appellant appears as serial number 5 of the set list. For ready reference, I have taken your lordship to that serial number 5, the appellant. Person dated by order dated this and order dated this, serial number 1 and 8 in the fit list, namely Srimati such and such and Srimati such and respectively were promoted to the rank of UPSI. It is pertinent to mention here that in the said fit list dated 31/3/2008, the name of opposite party number 7 is not mentioned because she has not done CPT. She went for CPT only in 2013.
Oh. 2008, she did not go.
Yes, she has not qualified even the CPT. As per the selection merit list, I am senior. CPT, I have qualified 5 years prior to her. E. That for the first time, the office of DGP Nagaland published a combined central list of both the male and female police in the rank of such and such. By OM, this. Most shockingly, in the said tentative central, the name of the appellant is not reflected, but name of opposite party number 7 is shown as serial number 7. Subsequently, the office of DGP Nagaland issued another OM publishing a tentative central list of FBSI, UPSI, and ASI or as on 30/6/2010. Superseding the OM dated 39/2009.
So in this tentative list, her name was not there.
My name was not there, but then opposite party number 7, but it's only tentative.
Tentative.
In the said tentative central list, the appellant is shown as serial number 10. But and the name of opposite number 7 is shown. I'm here, your lordship.
She's above.
In my respectful submission, tentative central list sense or central list is not relevant because as per the, for promotion to the post of from ASI to UPSI, it has to be as per the rules. Rule 34 says that it has to be after exhaustion of the list, fit list, then only next. It has the fit list has to be exhausted, the earlier fit list, then only you go to the say. And junior cannot be superseded. Senior cannot be superseded by junior, your lordship. Now promotion is purely based on the CPT.
But she did not object to this tentative seniority list.
That, your lordship, representation, I think, if I'm not mistaken, she has submitted representation, some representation. And there's also a final seniority list is also there, your lordship. And then, in fact, when this, at the time of, when this appeal was admitted, your lordship, that was on 1st of October 2010, your lordship. This court has raised the same issue. Yes, the final seniority list you have not challenged. But in my respectful submission, so far as promotion from ASI to SI is concerned, branch, it has to be as per the rule. The rule does not say about the seniority list as per CPT. And then junior cannot supersede senior, your lordship. Now, even so, that is why the writ petition was admitted on 1st of October 2024, your lordship. If I think that the Honorable CJ was there and Justice Manish Chaudhary was there. And that it requires consideration. So on that ground, it was admitted, your lordship. Now, H, that in the meantime, the Home Commissioner Nagaland by order dated 21/9/2011 promoted 15 UPSI to the rank of UPI, out of which 6 are women police. Consequently, the 6 vacant posts of UPSI occurred and which could be filled in the ratio of 50/50 basis by promotion, by way of promotion and direct recruitment. Therefore, the petitioner submitted representation dated this subject to consider her case for promotion based on the set ratio of 50/50 and also as per the fit list dated 31/3/2008. That is why it was said it was against the memorandum, but then it was late. There was delay in that portion.
Where is that 50:50 ratio?
50, the notification is there for promotion. So far as this appeal is concerned, of course, there is no relevant, but I think.
Okay, go ahead.
Now, Your Worship, that whereas against the whereas against the said 6 vacant posts, the DGP Nagaland by order dated such and such directly recruited 3 persons to the post of UPSI. No SI women police were promoted to the post of UPSI. In other words, the representation submitted by the petition for promotion to the post of UPSI in the ratio of 50:50 was not considered, and thereby arbitrarily and illegally depriving the appellant from being promoted to the post of UPSI. J. That the CPT of ASI was conducted from 25/9/2013 to 26/9/2013. Based on the CPT, by order dated such and such issued by the office of the DGP Nagaland, 50 ASI, both male and female, which have taken to your lordship, were declared passed and kept in the fit list for promotion to the next higher rank of UPSI. In the said order dated 4/10/22, it is categorically mentioned that ASI in the fit list will be given promotion as per the sequence arranged in the fit list, in order of seniority come merit to the rank of UPSI. Most shockingly, in the said fit list, the name of opposite party number 7 is shown as serial number 33, whereas the name of the appellant is shown as serial number 44. I have taken your lordship to that. As stated, the appellant has passed CPT as early as in the year 2008. Therefore, in the said fit list, the opposite party number 7, having cleared CPT only in the year 2013, cannot be placed above the appellant. Illegality in the action of the authorities is therefore writ large. Needless to say, even in the fit list for promotion, the appellant has been discriminated by the authorities. Not only 50-50 ratio, but even in fit list. So being agreed by the fit list that is such and such, the appellant again submitted representation. The record speaks for itself that the authority has treated the appellant almost arbitrary discrimination, and therefore the appellant approached this honorable court by way of filing writ petition 10 of 2014, challenging amongst other the fit list issued during such and such. During the pendency of the said writ petition, as per the fit list issued by order dated 4/10/2013, which is under challenge, the response number 4, DGP Nagaland, by order dated 30/3/2015, promoted the opposite party number 7 along with others to the post of UPSI. The appellant therefore paid for withdrawal of the writ petition, and this honorable court by order dated such and such allowed the appellant to withdraw the said writ petition with the liberty to file a refresh. Accordingly, the appellant filed a connected writ petition being such and such, incorporating the impending and the said promotion order and praying for quashing and setting aside the same, and to promote the appellant to the rank of UPSI with retrospective effect as per CPT list dated 31/3/2008, your worship. Now, grounds for appeal, your worship, starts from page 37, but my main grounds for appeal is that there was no delay on that. So far as prayer number 10, 13, and 14 is concerned, your worship. Now,
No,
Now-
learned single judge has not returned the finding that there is delay as far as the fit list thing is concerned.
no,
So-
totally silent, your worship, totally silent.
What is the findings with regard to fit list by learned single judge?
Feel is your, it's as the only reference given which I've taken your worship to your worship. That is para 48, starts from para 48.
Now that we have seen.
Hmm.
Yeah.
Somewhere, just vague reference, otherwise no findings.
Acha, 47. I think.
No findings, your worship. Now, but it is permitted to place 2 case laws, your worship. Yes. I've taken a little more than 1 hour, your worship. But on writ appeal, your worship, extent of interference, your worship, to what extent? Now, this is
Starline.
This is reported in Starline 2001, volume 1 GLT, page 710, your worship, GLT, para 20. Para 20, Your Lordship. Your Lordship will have to come to the next page after about 8 line from top. Thus, unlike an appeal, Lordship is, thus, unlike an appeal, in general, a writ appeal is an appeal on principle, and that is why, unlike an appeal in an ordinary sense, such as a criminal appeal, where the whole evidence on record is examined anew by the appellate court, what is really examined in the writ appeal is the legality and validity of the judgment or order of the single judge, and it can be set aside or should be set aside only when there is patent error on the face of the record. In my respectful submission, Your Lordship, as per the record, there is patent error. Well, there's no delay on the part of the petitioner in approaching this now, Your Lordship. So far as prayer number 10 and 13 is concerned. 14, Your Lordship, is consequential. Now, the next case which I would like to rely, Your Lordship, this is reported in short judgment 2006, volume 9, SEC 379, para 6. Short paragraph, I will read out. Para 6. Having regard to the facts and circumstances of the case, we are satisfied that the High Court ought to have disposed of the writ petition dealing with all contentious issues. That is the thing. In view of the relief sought for in the writ petition, under the circumstances, without stating anything more on the merit of the respective condition, we set aside the intent order, remit the writ petition to the High Court to dispose of it on merit dealing with all conditions raised by the appellant. So that is my case on your. So there was no delay for the record.
Yes. Yes. Yes.
May I please, Lordship? Lordship, first of all, the appellant, he had not challenged, she had not challenged the final seniority list on the basis of which the opposite number 7 was given promotion. Then secondly, Lordship, even in our affidavit, as well as in the judgment also, it has been recorded that the government, we do not have the statutory rules for regulating recruitment and other service conditions for ASI, UBSI, and ABSI. Lordship, for that matter, I may be allowed to take you to page 283 of the judgment. Page 283, para 27. I may be allowed to read. In paragraph number 10 of the said affidavit in opposition, it was mentioned that there are no statutory rules for regulating recruitment and other conditions of service of ASI, UBSI, ABSI, and recruitment to this post is done as per notification number such and such dated 24/9/2004, issued by the government, whereby the power of recruitment of UBSI, ASI, ABSI in the Nagaland Police is delegated to the Director General of Police. Further to that, it was mentioned that when the government has taken a decision that the seniority of the Inspector of Police shall be determined on the basis of seniority in the grade of Sub-Inspector of Police in accordance with the principle of seniority, and had encountered all posts of unarmed branch inspector women police with the unarmed inspector male for maintaining common cell of promotion for both male and female posts, it was within the competence of the Director General of Police to maintain the same uniformity in the lower hierarchy of the posts of UBSI, ABSI, and ASI. Para 28. In paragraph number 19 and 21, it has been mentioned that the decision of the government to have a common seniority list of male and female officer in UBSI, ASI was way back in the office memorandum dated 5/7/2011, and the same was circulated to all concerned. However, the petitioner chose to sit over the matter, Lordship, and approached the court only sometime in the latter part of January 2014 by filing the writ petition, which was, however, withdrawn via the order dated 10/2/2016. It was further mentioned that in the instant writ petitions, there was no explanation whatsoever as to why there was a delay in challenging the office memorandum dated 5/7/2011. It was also mentioned that the tentative seniority list published by the department via memorandum dated 13/9/2009, 17/8/2010, and 15/7/2011, though had been challenged by the writ petitioners, but the petitioners have not challenged the memorandum dated 2012/2011. This is the common final seniority list, wherein the common final seniority list of UPSI and LSI was published, and in absence of any challenge to the memorandum dated 2012/2011, the petitioners do not have the legal rights to challenge the promotion of the senior ASI to UBSI, which have been effected by the impugned order. Then, Lordship, with regard to the fifth list, the learned single judge has come to the conclusion that is at page 296. Paragraph 47. Paragraph 47. At this stage, it is also relevant to take note of that there is no right to promotion. A person only has a fundamental right to be considered for promotion. Even if this court looks into the order dated 31/3/2008, this is the fifth list, it would be seen that the petitioners, along with others, have passed the central promotion test and was kept in the fifth list in the rank of UBSI women police. But the said promotion was subject to vacancy, having arisen as well as good SER for the preceding 5 years. Therefore, the question of granting relief to promote the petitioners to the rank of UBSI women police with retrospective effect as per the CPT fifth list dated 31/3/2008 cannot be granted unless and until any vacancy arises. Then with regard to the delay in ledgers, para 49. Before further proceeding on deciding the question of the relief that can be granted, it would also be relevant to take note of the question of delay in ledgers. The appointment of the respondent number 7 to 17 as direct recruits was made on 22/1/2008. The said appointment, though contrary to the office memorandum dated 9/6/1966 of the Government of Nagaland Home Department, and more particularly clause 4 therein, but the said appointment were sought to be challenged firstly in the year 2014 and thereafter by way of the present writ petition. In the opinion of this court, the said challenge on the face of it suffers from delay and ledgers. Then, my lord may come to page 298, para 50. Third line from bottom. Thereafter, on January 2014, the petitioners for the first time approached this court by filing 3 separate writ petitions, that is, such and such. While the said petitioner were pending, there were further promotion made to the rank of UBSI, for which the petitioner withdrew the said writ petition on 10/2/2016, and after 3 months filed the present writ petition on 31/5/2016. Para 51. The petitioner have not assigned any reason as to why there has been a delay of almost 3 years in challenging the minutes of the meeting dated 2/7/2011, the memorandum dated 5/7/2011, and the impugned seniority list dated 15/7/2011. In view of such delay, rights have occurred upon others while the petitioners were sitting idle. It would also be seen that it was after more than 1 year the petitioner filed the first representation, and thereafter the second representation was filed on 26/10/2013. The impugned minutes of the meeting dated 2/7/2011 and memorandum dated 5/7/2011 and subsequent memorandum dated 15/7/2011 were known to the petitioners, and there was nothing which prevented the petitioner from approaching this court. And interference with the actions of the respondents at this stage would settled matters, which would lead to several complications. Consequently, this court therefore holds that on account of delay and lectures, no writ can be issued as regard the relief sought for in the instant writ petition. So, Lordship, there is nothing infirmity in the learned single judge judgment because the law has already been, position has already been settled. So now to unsettle that already settled, it would create more complication. And first of all, also the learned single judge has taken into consideration all the statutory rules, the fit list, and even the question of delay and lectures raised by the state government. That's all.
And if you know, one question, what we
Yes,
have
yes.
raised is about this manual. That has not been placed before the learned single judge. Because learned single judges went on the line, seniority list was not challenged, and so and so. But what about this?
In our affidavit in opposition, we have clearly mentioned that there is no statutory rules. I'll show.
This manual is statutory rules.
But then it was not placed in the writ proceedings. Right. It was
Yes.
not placed, I think.
It was not a
It
procedure.
was not placed, not considered. Now that this is a new ground,
Your worship, that
there will be a delay in latches in challenging the seniority list. That was in 11.
Yes.
Right. Now that new facts and because of this manual, you have a different ground. That has not been, what is the answer?
Lordship, may come to page 208 of our affidavit.
Page 20.
208, yes, para 6. para 6. Second line from the bottom, the deponent.
Yes.
The deponent.
No statutory rule.
Yes, for relating recruitments and other condition of services of ASI, UPSI, and ABSI. And the recruitment to the post is done as per the notification number such and such dated 24/9/2004.
And it was
issued by the
delegated
government, yes.
to DGP.
Yes, yes.
That is your stand.
Yes, that is our stand, based on which.
What about application of this? Whether this, he's saying it has a statutory force. What do you say on this? Like our Assam police manual. These are followed. This is under 309.
If it is under 309, the lordship, it is a law.
Yes.
In that case, he has a case. After
There is
exhaustion,
article, yes.
it was not exhausted. New CPT done and all that. Okay, we will examine. no?
Lordship.
Any reply?
Only the reply which already be. That no, there is no statutory rules, that is not correct, Your Lordship. Here the manual is there, 2010, which has been notified and has been notified. This is framed under 309. Now, another submission advanced by the council for the state is that promotion was given as per the seniority list. No, for promotion to the post of SI from UPSI, that has to be as per the manual. And manual rule 34 is clear. It has to be as per the seniority list, not seniority list. Otherwise, don't.
But we want to see what state cities.
So notification.
We'll take out documents and ask them to
This will be because it was notified electricity.
And third, Your Lordship. Now, learned single judge has observed that, yes, appellant, I have no right for promotion. But my
That is a subtle position.
my submission is at least I have a right to be considered for
That is
promotion
the law.
as per fit list 2008. That is
Right to be considered. You do not have rights.
yeah. But I have not been considered even as per 2008 fit list. That is the case. That's all.
Okay. Mr. Ajam. Learned counsel for the appellant. We have also heard Ms. Sukri, learned additional AG for the respondent.
1 to 6.
Respondent number 1 to 6. And respondent number 7.
There's none appeared, though notice is completed.
Okay. None appears on behalf of the respondent number 7. So, hearing concluded, judgment reserved. Okay.
Much obliged, Your Lordship.